The House will come to order. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Mr. Gregorio, please call the roll.
Representatives Amabile, Arndt, Bacon, Representative Bacon. Representative Bacon is excused. Baisley, Benavidez, Representative Benavidez, Burnett, Byrd, Representative Byrd. Representative Byrd is excused. Bockenfeld. Okay. Bradfield. Caraveo. Representative Caraveo. Representative Caraveo is excused. Carver. Catlin. Cutter. Doherty. Duran. Escar. Exum. Froelich. Geithner. Gonzalez Gutierrez. Gray. Hanks. Herod. Representative Herod is excused. Holtorf. Hooten. Representative Hooten. Jackson. Judah.
Here.
Kennedy. Kip. Larson. Montine. Luck. Representative Luck. Lynch. McCluskey. McCormick. McKean. I'm here. McLaughlin.
Present.
Michael St-Genet. Mullica. Neville. Ortiz. Pelton. Pico. Ransom. Rich. Ricks. Representative Ricks. Representative Ricks is excused. Roberts. Representative Roberts. Sandridge. Sirota. Snyder. Soper. Sullivan. Tipper. Titone. Valdez A. Valdez D. Van Bever. Representative Van Winkle. Representative Van Winkle. Representative Van Winkle is excused. Weissman. Will. Williams. Woodrow. Woog. Young. And Mr. Speaker.
He's there.
With 63 present, 2 excused, we have a quorum. Representative Luck.
Thank you, Mr. Speaker. I move that the Journal of Tuesday, March 30th, 2021 be approved as corrected by the Chief Clerk.
You've heard the motion that the journal be corrected by the Chief, be approved as corrected by the Chief Clerk. All those in favor say aye. I heard one. All those opposed, no. Yeah, the one eye clearly has it. The motion is adopted. Announcements and introductions. Representative Valdez.
Good morning, everybody. Just wanted to make the announcement that House Energy and Environment will be canceled today. Tomorrow, we will be meeting in the Old State Library to hear 1243, 006, 1149, and potentially one more bill. So stand by, but for today, members of Energy and Environment, we are not meeting.
Representative Exum.
Thank you, Mr. Speaker. House Transportation Local Government Committee will be meeting this afternoon to hear House Bill 1139, 1168, and 1235, 130 LSBA. Be there.
Representative Weissman.
Thank you. Good morning, Mr. Speaker. Judiciary Committee members, we are meeting 1:30 this afternoon in 107. We will hear House Bill 1001 and 1142. Late-breaking request after the calendar was closed for today. We're laying over 1182. We will hear that at a future point. So again, today is 1101 and 1142 only. Thank you.
Representative Burnett. Members, please draw your attention to the well. Representative Burnett.
Thank you, Mr. Chair. Yesterday, I attended Officer Eric Talley's service, and I learned a couple things. He loved three things. He loved being an officer. He loved being on the Boulder Police Department drone team so he could use his IT experience. And of course, he loved his family and his 7 children. Many of you have learned about when he made the national news a couple years ago when he rescued ducklings from a ditch. But what I learned yesterday is that many of the people, the professionals in the behavioral health services, often noted how empathetic Officer Talley was. The most important thing I learned, I learned yesterday that Officer Talley saved lives. When people ran out, he ran in. When he entered the building, no one else died. Officer Talley saved lives. Thank you.
Thank you, Representative Burnett. Representative Wantine.
Thank you, Mr. Speaker, and while that's a tough act to follow, my news seems to pale in the comparison. I just wanted to notify everybody that the Health and Insurance Committee will not be hearing House Bill 1232 today. We still have on the calendar House Bill 1202, and we'll see everybody then. Thank you.
Further announcements and introductions. Representative McLaughlin.
Thank you, Mr. Speaker. Good morning. House Education will be meeting today. We're going to hear Senate Bill 157, and we'll see you at adjournment. Thanks.
Thank you, Representative McLaughlin. Further announcements and introductions. Seeing none, Majority Leader Escar. Great. Before we go there, let's do reports of committees of reference.
Committee on Health and Insurance, after consideration on the merits, the committee recommends fine. Senate Bill 92 be referred favorably to the Committee on Finance. Senate Bill 93 be referred favorably to the Committee on Appropriations. Senate Bill 97 be referred favorably to the Committee on Appropriations. Senate Bill 102 be referred to the Committee of the Whole with favorable recommendation. Committee on Public and Behavioral Health and Human Services, after consideration on the merits, the committee recommends the following. House Bill 1222 be referred to the Committee of the Whole with favorable recommendation. Senate Bill 122 be referred to the Committee of the Whole with favorable recommendation. Senate Bill 115 be referred favorably to the Committee on Appropriations. House Bill 1166 be amended as follows and be so amended, be referred to the Committee on Appropriations with favorable recommendations. Committee on Transportation and Local Government, after consideration on the merits, the committee recommends the following. House Bill 1095 be amended as follows and be so amended, be referred to the Committee of the Whole with favorable recommendation. House Bill 1186 be amended as follows and be so amended, be referred to the Committee of the Whole with favorable recommendation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move to lay over the third reading calendar till tomorrow, April 1st.
Seeing no objection, the third reading calendar will be laid over one day till Thursday, April 1st. Majority Leader Escar.
Thank you, Mr. Speaker. I move that the following bills be made special orders at 9:14 a.m. Senate Bill 12, House Bill 1108, Senate Bill 122, Senate Bill 102, and House Bill 1187.
Thank you, Madam Majority Leader. You have heard the motion. Seeing no objection, the bills listed by the Majority Leader will be made special orders at 9:15 a.m. Representative Titone. You have heard the motion. Seeing no objection, Representative Titone will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the Majority Leader, and the coat rule is relaxed. Mr. Gregorio, please read the title of Senate Bill 12.
Senate Bill 12 by Senator Donovan, also Representative Roberts, concerning measures to create opportunities for persons who acquire experience in wildland fire services through the Inmate Disaster Relief Program.
Representative Roberts.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you, too.
I move Senate Bill 12, and there are no committee reports.
To the bill.
Thank you, Madam Chair. Colleagues, Senate Bill 12 is a very exciting bill. It establishes in statute that SWIFT firefighters, these are firefighters who were trained using state dollars to fight fires while they were incarcerated. This bill says that they are not prohibited from gaining employment as wildland firefighters with the Department of Public Safety once they are released from prison. It also directs the Department of Corrections to promote this job opportunity to those inmates while they are incarcerated so that they know this is a realistic possibility for them upon their reentry into society. Members, this is a really important bill for several reasons. First, by encouraging former inmates to join our wildland firefighting forces, we accomplish a twofold goal.
We better equip our state to fight forest fires that we all know are increasing at an alarming rate. And we offer formerly incarcerated individuals a path back into our communities with a solid employment opportunity. 3 of the largest wildfires in Colorado's history happened this past summer in many of our districts, and our inmates, these inmates were on the front lines. They protected our homes, our property, our forests, and our lives. Our state has already invested the time and resources to train these individuals to do this important job, and it only makes sense in a time of increasing wildfire to utilize their skills and bravery to protect our communities and to create job opportunities across the state. I ask for an aye vote.
Representative Sandridge.
You listening? Thank you, Madam Chair. Love this bill. I do. I don't think that's very too much of a shocker to anyone. But there's I'll take a different look at this. This is a fiscally responsible bill. This will help with recidivism. A lot of times when you get out of jail, when you get out of prison, the government says, everybody says, get a job, get a job. Well, this helps you get a job. So I think we need actually more of this, where we're giving these former inmates certain opportunities or helping them gain certain opportunities, so they're not back in prison, costing taxpayers money. So I think in the long run, this will save taxpayers money. I think it's the right thing to do, and we actually need more of these. It'll benefit everyone. Thank you.
Representative Will.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you, too.
I come up in strong support of this bill. In my past life and my career, I worked with the SWIFT crews a lot from Department of Corrections. I worked those crews on fires, also fire mitigation type work. They do a lot of that work. These are great crews. They're well trained. And those SWIFT crews are every bit as good as the hotshot crews on these fires. So I'm in strong support of this bill.
Representative Herod.
Thank you, Madam Chair. Members, I just want to also rise in strong support of this bill. We know that Colorado has been in extreme fire danger for a while now, and we anticipate it continuing. Unfortunately, we haven't had enough folks employed to respond, and we have a crew of folks who are ready and trained and willing to be a part of those teams to respond to the fires. This is something that's been brought up through DOC as well as public safety and our emergency response team. I'm really glad to see Representative Roberts take the lead and take the charge on this. While it doesn't require folks to get hired, what it does do is lift any prohibition or any challenge with them getting hired. And so I'm glad to see this bill. I'm glad to see it move forward after, I think, 3 or 4 years of conversation. And I look forward to seeing these folks get gainfully employed fighting for Colorado and fighting fires. I ask for a yes vote.
Representative Pelton.
Thank you, Madam Chair. And I guess I have a question for the bill sponsor. Page 4, it says that at the bottom, division is encouraged to hire persons who acquired experience. My question is, does this bill, this program, give preferential treatment to the inmates over someone who's paid the money and gone and gotten trained? That is my question.
Representative Roberts.
Thank you, Madam Chair, and thank you, Representative Pelton, for the question. So page 4, section 3 is about the Department of Corrections promoting this opportunity while these individuals are incarcerated, because the problem is right now is they go through all this training and they actually do the firefighting, but they don't know that this is a viable career path for them. So this creates this asks the Department of Corrections to promote it to the inmates while they're there. But no, in general, this doesn't create preferential treatment. It just says that the fact that you have been incarcerated cannot be the sole reason that you're denied employment in the program.
Any further discussion? Representative Doherty.
Thank you, Madam Chair. I just wanted to say that I'm very supportive of this bill. My brother has a felony and he's had addiction issues, and I have watched him time and time again try to pull himself up, but be told no. He actually went through a whole wildlife rescue course, and he's not in Colorado, he's in Idaho. But he went through a whole course of training because that's what he wanted to do, is to help people and be useful and feel like he's giving back. And at the end of that training and after passing that course, he was told by his probation officer that he could not actually do that because of his felony. So again, I really support this. I think it's really important to make sure people have hope and a purpose, and I think that that's what this bill allows. Thank you.
Representative Van Bibber.
Thank you, Madam Chair. I am rising in support of this bill. I received a letter from a former inmate in California who specifically wrote to Colorado representatives to ask us to consider this bill and rise in support of it. This gentleman was part of a legacy and a family of dysfunction that, of his own admitting, landed him in prison. Taking responsibility for...
Members, can you please take your conversations off to the side, please? It's getting loud in here. Please continue, Representative Van Bibber.
Taking responsibility for his own choices, he served his time, but he did have the opportunity to fight fires in California, at which point he divulged he found a sense of purpose. And he admitted that it was quite possible that the reason he ended up in prison in the first place is because he didn't know where to go in life. He shared that that experience allowed him to change generational dysfunction, that he had a sense of hope that from that point forward, his family and the families of the children that he would hope to have would change the course of their life forever. So I do rise in support of this bill. It does give a sense of purpose, and it gives people the hope that they can change and live a better life. I ask for an aye vote on this bill.
Representative Holtorf.
Thank you, Madam Chair. I too rise in support of this bill, and there's other legislation that's being promulgated that follows this same theme coming through the House later this session. But here's the story that I want to tell to have people understand how important this type of legislation is. Many of these convicted felons or ex-cons, as they say on the street, are looking for an opportunity to do something in their lives productive. Years ago in this country, we had a policy in military service that oftentimes a felon was looking at the judge, and the judge says, and of course this was during the draft years, the judge says, you know, I can send you to prison, or I can send you to the military. You'd make the choice. Or maybe they didn't get the choice. But the story I want to tell is a true story about a staff sergeant that served under my command who was my scout platoon sergeant overseas. And you know, in the military you get to know people pretty well, and eventually they start telling you more about them than maybe you ever wanted to know. But this particular individual said, you know, years ago I was in a holdup at a liquor store with my buddy down in Queens. And we held up the store, stole the money, and my buddy shot the owner square in the chest, killed him. And this was back in the late 60s, early 70s when this happened. Of course, we're in the 90s now. And time has passed. The sands of time have passed. But this individual said to me, thank God the judge told me to join the military, because it gave me a new lease on life. And I know I did wrong. And I'll reconcile that when I go to meet my Maker. But I know I did wrong and we did wrong. Now, I didn't pull the trigger, but I was there and I could have stopped it. And I didn't stop it. So what he told me is the military gave him a new lease on life. He proudly served his career and made the rank of staff sergeant and had many soldiers under him and served with pride, and also got an honorable discharge. at the end of his service. This type of program right here, if you allow former inmates to get into firefighting, they too can get a new lease on life. They too can go out and do something productive for their communities, feel proud about what they do, and have a very similar story that I just told. So thank you for bringing this bill.
Representative Exum.
Thank you, Madam Chair. Members, I rise in strong support of this bill. Many of you know I'm a retired firefighter from Colorado Springs, and this is a worthy career. And this is basically an opportunity for a second chance to show and appreciate the recognition that these inmates have shown, their dedication to the training while they're incarcerated, and they deserve a second chance to make good on that. So I rise in strong support. Thank you.
Any further discussion on Senate Bill 12? Seeing none, the question before us is the passage of Senate Bill 12. All those in favor say aye. Aye. Anyone opposed, no. The ayes have it. Senate Bill 12 is adopted. Mr. Gregorio, please read the title of House Bill 1108.
House Bill 21-1108 by Representative Escar, also Senator Moreno, concerning updates to prohibitions against gender-based discrimination to clarify the individuals who are included in a protected class.
Majority Leader Escar.
Thank you, Madam Speaker. Madam Chair. I move House Bill 1108 and the Judiciary Committee report.
To the Judiciary report.
Thank you. In the committee, we ran a amendment that upon further review of the bill, we were worried that removing certain language from the definition of sexual orientation might have unintended consequences, so we ran an amendment to fix that. Ask for an aye vote on the committee report.
Representative Soper to the report.
Thank you, Madam Chair. I move Amendment L004 and ask that it be displayed.
The committee report?
Yeah. It deletes sexual orientation. So it takes it back to current law.
Amendment L004 has been moved and is displayed. Representative Soper, go ahead and continue.
Well, thank you, Madam Chair. So the amendment was made to the definition of sexual orientation. What this amendment does to the committee report is it deletes that definition so that we go back to the definition that's currently in law. And I would ask for a yes vote.
We'll have a quick recess here while we take a look at that amendment.
What? Could you repeat it? What'd you say? Why?
All right, we're back from recess. Majority Leader Escar.
Thank you, Madam Chair. Actually, would just ask for a no vote on this amendment. It's not necessary.
Any further discussion on Amendment L004 to the committee report? Seeing none, the question before us is the adoption of Amendment L004. All those in favor say aye. All those opposed, no.
No.
The amendment is lost. The question now, any discussion on the committee report? Seeing none, the question before us is the adoption of the committee report. All those in favor say aye. All those opposed, no. The committee report is adopted. Majority Leader Escar to the bill.
Thank you, Madam Chair. Members, right now, current law protects individuals from discrimination based on a variety of factors, including race, gender, sexual orientation, and religion. All 1108 does is modernizes the law to codify existing practice. Let me repeat that. To codify existing practice and ensure that the protections currently extended under sexual orientation actually include an individual's gender expression and gender identity. For those of you who may not know, sexual orientation, gender identity, and gender expression are three very different things, and right now we put it all under sexual orientation. 1108 recognizes the current thinking and practice that an individual's gender identity and gender expression are very different than a person's sexual orientation. That's all we are doing with this bill. We are modernizing the law to codify existing practice. I ask for an aye vote.
Any further discussion on how Representative Soper?
Well, thank you, Madam Chair. So members, I served on House Judiciary Committee the day this bill was heard. And one thing that definitely troubled me about this bill is I was part of the effort to get the gay panic defense abolished here in Colorado. And that was the first time in Colorado law that we definitely introduced the definition that is being talked about in this bill, gender expression and gender identity in the Colorado law. And I believe that law should be consistent across the board, going from one statute to another statute, and that for clarity of understanding what we're talking about, that those definitions remain the same. I guess was a little bit troubled to see that we are changing quite a bit already in 1 year's time from what our current definition in law is to a new definition, which is why I move Amendment L002. Give you a copy.
Hey, thanks.
And ask that it be displayed.
All right, Amendment L002 has been moved and is displayed. Please continue.
Thank you, Madam Chair. So this amendment takes the definitions back exactly to the way they are in current law so that we have consistency within law, so that a citizen who's reading one part of the statute books can know what the definition is throughout the entire statute books. And I would ask for a yes vote. Thank you.
Majority Leader Eskar.
Thank you, Madam Chair. Members, I'd ask for a no vote. We discussed this in the committee. When the legislature approved Senate Bill 221 last year, by near unanimous vote, the bill added into statute combined definition of gender identity and gender expression, and that combined definition was drafted to ensure functionality during legal and courtroom proceedings. This bill, though, provides individual definitions of both terms that slightly differ than what was used in 2021. House Bill 1108, again, is a way of implementing common language instead of relying on enumerated lists that, as we know, quickly become outdated. I ask for a no vote.
Any further discussion on Amendment L002? Seeing none, the question before us is the adoption of Amendment L002. All those in favor say aye. Aye. All those opposed, no. The amendment fails. Back to the bill, Representative Soper.
Thank you, Madam Chair. It's very quick. Since we're not going back to the definition that's currently in law, I'm still troubled by the definition that we have here in House Bill 1108. One thing that we talked about in committee, and is one thing that definitely drives those of us who have a law background, is to have a definition in law where you have a term like typically within an objective definition, because all of a sudden that makes it very subjective. It presents a laundry list of items after the word typically in order to describe what the first part of the definition is trying to convey. This can be very confusing. As a matter of fact, so confusing that during committee, I asked a couple of the attorneys who were testifying why it is that this laundry list of items after the word typically did not include other items that have been presented in the case law, because what we heard over and over again is that the effort here was to codify current case law. However, it was quite easy, even during committee, to find additional terms that are supposedly well-settled case law that were specifically not included in this definition. So if the whole point is to add clarity so that citizens understand what the meaning of gender expression is, or gender identity is, in particular gender expression, then we've really confused them if we have areas that are supposedly settled case law that were specifically not included here. In particular, mannerisms and speech were specifically not included here, which typically should be. That's why, Madam Chair, I move Amendment L007 and ask that it be displayed. Majority Leader Eskar.
All right, L007 is moved and displayed. Please continue, Representative Soper.
Thank you, Madam Chair. So this amendment does exactly what I was just talking about. It deletes the word typically and the list after. So if we're going to have clarity, we either need to have, everything that's talked about in case law included so that we have clarity, which probably would be an incredibly long list. And one thing that we heard during committee is that if we were to include everything that's been considered during case law, then we would really confuse citizens. I would like to go back to a very objective definition where we don't have the word typically in everything that
Representative
follows.
Soper, hold on one second. Members, please keep it down in the chamber. Please continue, Representative Soper.
Thank you, Madam Chair. I appreciate that. And to really add clarity to the definition, because having a phrase like typically and then a laundry list that follows really just serves to confuse people. And I believe we have a duty as lawmakers to provide at least the best language that we can rather than more confusion into the law. And I would ask for a yes vote.
Representative Weissman.
Thank you, Madam Chair. And, I always appreciate a conversation with a judiciary colleague in terms of the role of clarity in the law. I'm going to ask for a no vote here for a couple of reasons. One, what we're talking about here does revolve around things like appearance, dress, and behavior. I think that's integral to the kind of protection in non-discrimination law that we're trying to set forward. I think that's just core to the modernization and updating work that 1108 seeks to do. Also, to the use of the word typically, we did talk about this in Judiciary Committee as well. In an employment non-discrimination context, outside of this type of discrimination, it can be material whether a problematic type of behavior, for example, by a supervisor or another employee, is typical or not. I think you would find in the law different outcomes based on whether somebody says something inappropriate one time or whether there is a pattern, whether that course of conduct or behavior is in fact typical, to use this very word here. So I don't think that is a totally foreign concept to non-discrimination law, and for that reason, and because I don't think we want to militate against the point of the bill, I am going to ask for a no vote on this amendment.
Representative Soper.
Thank you, Madam Chair. So I did a little bit of legal research into the statutes, and one thing that I found is that typically is really only ever found in the footnotes in our Colorado Revised Statutes. And it's really to illustrate, like, these cases typically take months or years to resolve, and then it continues on to talk. Other areas where the statutes talk about typically is, for example, in the Education Code, it will say typically someone assumes or presumes something, but it's not in a definition. In scanning through all of our statutes, I could not actually find a definition in which the word typically was included. And I guess I find that kind of troubling that this is the very first time that we're including the word typically in a definition in Colorado law, because this definitely adds confusion for the citizen, especially when you don't have this. It's typically not what we do in lawmaking. And members, I certainly would ask for a no vote because this is an unprecedented move to a definition section in statute. Thank you.
Any further discussion on Amendment L007? Seeing none, the question before. Seeing none, the question before us is the adoption of Amendment L007. All those in favor say aye. Aye. All those opposed, no. The amendment is lost. Any further discussion on House Bill 1108? Seeing none, Representative Carver.
Nope, grabbed the wrong one. Here we go. I apologize, Madam Chair. I now have the appropriate amendment.
Okay. Go ahead, Representative Carver.
Thank you, Madam Chair. I offer Amendment L005 and ask that it be displayed.
All right, the amendment is moved and displayed. Representative Carver, go to the amendment.
Thank you, Madam Chair. Members, this is an amendment to the legislative declaration. The current legislative declaration in the bill references, quite frankly, a very narrow expression for freedom of religion that does not reflect the current constitutional law in this area. And it only references the state constitution, as opposed to the full case law that we have from the U.S. Supreme Court under the Bill of Rights First Amendment, which does apply in Colorado. And so this amendment, which is an amendment to the legislative declaration, is simply a more accurate statement of principle that everything in this bill, indeed every legislative act that we do in this body, is subject to constitutional restrictions protecting freedom of religion. And we have numerous cases by the U.S. Supreme Court that make it clear that freedom of religion goes beyond exercise of our faith in places of worship. It can apply in a hospital setting with the Little Sisters of the Poor. It can apply in various other places. Again, we are simply wanting the legislative declaration to accurately reflect the constitutional guardrails, in this case, freedom of religion, that is always in place, and that every piece of legislation must fit within those constitutional protections. And so with that, I would ask for an aye vote on the amendment.
Any further discussion? Representative Weissman.
Thank you, Madam Chair. You know, we're on important ground here. We're on the ground of constitutional rights. And I appreciate to my colleague on judiciary that this is just intended to be a change to the legislative declaration part of the bill. We have had a couple of significant and I think contentious cases come down from the United States Supreme Court in this domain in about the last 10 years or so. As such, necessarily construing not the state constitution, but the federal constitution and the federal Bill of Rights. You know, I'm not going to say that whatever anybody chooses to do in their place of worship, in their church, their mosque, their synagogue is necessarily our business. That's the private sphere. But what we are talking about here is equal treatment in the civil realm, including places of commerce, including places where healthcare may be accessed. And the Declaration specifically is talking about the comparable provision of our state constitution, Article 2, Section 4, which was not construed and could not have been construed by the United States Supreme Court in various holdings that have come down over the last 10 years. So I don't think it's appropriate, you know, for us to reach that broadly, both as to scope and to attempt to ascribe, in terms of what we, the legislature, are saying about our state Bill of Rights, to what was said by the United States Supreme Court about the federal Constitution and the First Amendment of the federal Bill of Rights there too. So I'm going to ask for a no vote on those grounds.
Representative Carver.
Thank you, Madam Chair. Thank you, Representative Wiseman. Well, respectfully, a legislative declaration as it currently exists, and I'll just read it, it's on page 3. The General Assembly hereby finds, determines, and declares that nothing in this act is intended to impede or otherwise limit the protections contained in Section 4 of Article 2 of the state constitution concerning the free exercise and enjoyment of religious profession and worship. I have no quarrel with that statement, but it is incomplete. Obviously, the whole intent of the legislative declaration is to recognize and capture in this document some of the key constitutional protections which can arise and that the General Assembly is recognizing. So, because the freedom of religion protections established by Supreme Court case law, right? Already established law. As is, we have established case law under the state constitution. We are simply recognizing that federal case law on freedom of religion applies in Colorado, as does the vast majority of the Federal Bill of Rights. And that all of those cases and how freedom of religion is defined, which is evolving as cases come forward, we are recognizing and including in the legislative declaration that we recognize that freedom of religion in places under current federal case law beyond enjoyment of religious profession and worship. That it is significantly broader than what is stated in the bill. And so would ask for an aye vote.
Any further discussion on Amendment L005? Seeing none, the question before us is the adoption of Amendment L005. All those in favor say aye. Aye. All those opposed, no. The amendment fails. To the bill, Representative Carver.
Thank you, Madam Chair. I offer Amendment L006 and ask that it be displayed.
All right, Amendment L006 has been moved and displayed. Representative Carver, why don't you tell us about the amendment?
Thank you, Madam Chair. An important line of cases under First Amendment freedom of speech that is rarely discussed in media or public venues is a line of cases against compelled speech. So the First Amendment doesn't only protect the right that you and I have to transmit information and receive information. It doesn't only protect or prohibit the government from making regulations that favor one form of speech over another, the line of cases that require government regulation to be content neutral, but an important line of cases that protects citizens, businesses, organizations from being compelled to adopt or sponsor or put forth speech with which they do not agree. And this, I have to give special thanks that since this is one of my favorite parts of the First Amendment, it allows me to go into these wonderful constitutional law books on compelled speech. And how does this fit in here? We have a line of cases, starting with the most important case in 1943, establishing what it is to protect citizens from being forced to sponsor or adopt speech or conform their speech with what a particular government law or regulation prescribes. And this can take the form, as it usually does, of oral statements. But speech has been expanded to include artistic expression, to include a whole range of nonverbal speech, which still has the full protection of the First Amendment. And in fact, we had some very important recent cases. The National Institute of Family and Life Advocates versus Harris decision just a few years ago, where pregnancy centers were required to post a notice about right to abortion. And that was struck down as compelled speech. We have within our own state instances where this issue is currently being litigated. What is the extent of artistic expression that is protected by the First Amendment? And the courts will ultimately sort that out. We also have a case that was rendered last week in the Sixth Circuit on a particular regulation that applied to university faculty, which prescribed certain ways that certain pronouns needed to be used. And that was struck down as violation of the First Amendment, compelled speech. So all this amendment does, members, is recognize that First Amendment, freedom of speech, but also the protection against compelled speech, is an important constitutional principle that we are recognizing expressly in the legislative declaration. And so I ask for an aye vote.
Any further discussion on Amendment L006? Majority Leader Escar.
Thank you, Madam Chair. Members, I'd ask for a no vote on this amendment.
All right, Representative Van Bibber.
Thank you, Madam Chair. On March 26, 2021, the United States Court of Appeals from the Sixth Circuit just handed down their decision on First Amendment. The Court of Appeals decided traditionally American universities have become beacons of intellectual diversity and academic freedom. They've prided themselves on being forums where controversial ideas are discussed and debated. And they have not tried to stifle debate by picking sides. But Shawnee State chose a different route. It punished a professor for his speech on a hotly contested issue. And it did so despite the constitutional protections afforded by the First Amendment. The district court dismissed the professor's free speech and free exercise claims. We see things differently and reverse. The district court decided this case on a motion to dismiss, so we construe the complaint in the light most favorable to the plaintiff. This means that we must accept the complaint's factual allegations as true and draw all reasonable inferences in Meriwether's favor. Handy Clay v. City of Memphis. Under this standard, we must reverse the district court's dismissal unless it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. Quoting Guzman v. the United States Department of Homeland Security. Nicholas Meriwether is a philosophy professor at Shawnee State University, a small public college in Portsmouth, Ohio. Shawnee State began awarding bachelor's degrees just 30 years ago. And for 25 of those years, Professor Meriwether has been a fixture at the school. He has served in the faculty senate, designed a bachelor's degree program in philosophy and religion, led study abroad trips, and taught countless students in classes ranging from ethics to history of Christian thought. Up until the incident that triggered this lawsuit, Meriwether had a spotless disciplinary record. Professor Meriwether is also a devout Christian. He strives to live out his faith each day. And like many people of faith, his religious convictions influence how he thinks about human nature, marriage, gender, sexuality, morality, politics, and social issues. Meriwether believes that God created human beings as either male or female, that this sex is fixed in each person from the moment of conception, and that it cannot be changed regardless of an individual's feelings or desires. He also believes that he cannot affirm as true ideas and concepts that are not true. Being faithful to his religion was never a problem at Shawnee State. But in 2016, things changed. At the start of the school year, Shawnee State emailed the faculty informing them that they had to refer to students by their preferred pronouns. Meriwether asked university officials for more details about the new pronoun policy, and the officials confirmed that professors would be disciplined if they refused to use a pronoun that reflects a student's self-asserted gender identity. What if a professor had a moral or a religious objection? That didn't matter. The policy applied regardless of the professor's convictions or views on the subject. When Meriwether asked to see the revised policy, university officials pointed him to the school's existing policy prohibiting discrimination because of gender identity. The policy applies to all of the university's employees, students, visitors, agents, and volunteers. It applies at both academic and non-academic events. It applies on all university property, including classrooms, dorms, and athletic fields, and it sometimes applies off campus. Meriwether approached the chair of his department, Jennifer Polly, to discuss his concerns about the newly announced rules. Polly was derisive and scornful. Knowing that Meriwether had successfully taught courses on Christian thought for decades, she said that Christians are primarily motivated out of fear and should be, quote, banned from teaching courses regarding that religion, end quote. In her view, even the presence of religion in higher education is counterproductive. Meriwether continued to teach students without incident until January 2018. On the first day of class, Meriwether was using the Socratic method to lead discussion in his course on political philosophy. When using that method, he addresses students as Mr. or Mrs. He believes this formal manner of addressing students helps them view the academic enterprise as a serious, weighty endeavor and fosters an atmosphere of seriousness and mutual respect. He, quote, has found that addressing students in this fashion is an important pedagogical tool in all of his classes, but especially in political philosophy, where he and the students discuss many of the most controversial issues of public concern. In that first class, one of the students Meriwether called on was Doe. According to Meriwether, quote, no one would have assumed that Doe was female based on Doe's outward appearances. Thus, Meriwether responded to a question from Doe by saying, yes, sir. This was Meriwether's first time meeting Doe, and the university had not provided Meriwether with any information about Doe's sex or gender identity. After class, Doe approached Meriwether and demanded that Meriwether refer to Doe as a woman and use feminine titles and pronouns. This was the first time that Meriwether learned that Doe identified as a woman. So, Meriwether paused before responding because his sincerely held religious beliefs prevented him from communicating messages about gender identity that are false. He explained that he wasn't sure if he could comply with Doe's commands. Doe became hostile, circling around Meriwether at first, and then approaching him in a threatening manner. I guess this means I can't call you a CU, the rest to be determined. Doe promised that Meriwether would be fired if he would not give in to Doe's demands. Meriwether reported the incident to senior university officials, including the dean of students and his department chair, Jennifer Polly. University officials then informed their Title IX office of the incident. Officials from that office met with Doe and escalated Doe's complaint to Roberta Milliken, the acting dean of the College of Arts and Sciences. Dean Milliken went to Meriwether's office the next day. She, quote unquote, advised that he eliminate all sex-based references from his expression. No using he or she, him or her, Mr. or Mrs., and so on. Meriwether pointed out that eliminating pronouns altogether was next to impossible, especially when teaching. So he proposed a compromise. He would keep using pronouns to address most students in the class, but he would refer to Doe using only Doe's last name. Dean Milliken accepted this compromise, apparently believing it followed the university's gender identity policy. Doe continued to attend and participate in Meriwether's class, but Doe remained dissatisfied and, 2 weeks into the semester, complained to university officials again. So Dean Milliken paid Meriwether another visit. This time, she said that if Meriwether did not address Doe as a woman, he would be violating the university's policy. Soon thereafter, Meriwether accidentally referred to Doe using the title Mr. before immediately correcting himself. Around this time, Doe again complained to the university's Title IX coordinator and threatened to retain counsel if the university didn't take action. So Dean Milliken once again came to Meriwether's office. She reiterated her earlier demand and threatened disciplinary action if he did not comply. Trying to find common ground, Meriwether asked the university's policy would allow him to use students' preferred pronouns, but place a disclaimer in his syllabus noting that he was doing so under compulsion and setting forth his personal and religious beliefs about gender identity. Dean Milliken rejected this option out of hand. She insisted that putting a disclaimer in the syllabus would itself violate the university's gender identity policy. During the rest of the semester, Meriwether called on Doe using Doe's last name, and Doe displayed no anxiety, fear, or intimidation while attending class. In fact, Doe excelled and participated as much or more than any other student in the course. At the end of the semester, Meriwether awarded Doe a high grade. This grade reflected Doe's very good work and frequent participation in class discussions. As the semester proceeded, Meriwether continued to search for an accommodation of his personal and religious views that would satisfy the university. But Shawnee State was not willing to compromise. After Dean Milliken's final meeting with Meriwether, she sent him a formal letter reiterating her demand. Address Doe in the same manner as other students who identify themselves as female. The letter said that if Meriwether did not comply, the university would conduct an investigation and that he would be subject to informal or formal disciplinary action. Then, just a few days later, and without waiting for a response from Meriwether, Milliken announced that she was initiating a formal investigation. She claimed that she was doing so because she received another complaint from a student in Meriwether's class. The complaint was again from Doe. When Meriwether again asked whether an accommodation might be possible, given his sincerely held beliefs, Milliken shot him down. She said he had just two options. Number one, stop using all sex-based pronouns in referring to students, a practical impossibility that would also alter the pedagogical environment in his classroom. Or two, refer to Doe as a female, even though doing so would violate Meriwether's religious beliefs. Dean Milliken referred the matter to Shawnee State's Title IX office. Over the coming months, the university's Title IX staff conducted a less than thorough investigation. They interviewed just 4 witnesses, Meriwether, Doe, and 2 other transgender students. They did not ask Meriwether to recommend any potential witnesses. And aside from Doe and Meriwether themselves, none of the witnesses testified about a single interaction between the two. Shawnee State's Title IX offices concluded that Meriwether's disparate treatment created a hostile environment in violation of the university's non-discrimination policies. Those policies prohibit discrimination against any individual because of gender identity. They define gender identity as a person's innermost concept of self as male or female, or both, or neither. And they define a hostile educational environment as any situation in which there is harassing conduct that limits, interferes with, or denies educational benefits or opportunities from both a subjective, the complainants, and an objective, reasonable person's viewpoint. The Title IX report concluded that because Doe perceives themselves as female, and because Meriwether has refused to recognize that identity by using female pronouns, Meriwether engaged in discrimination and created a hostile environment. The report did not mention Meriwether's request for an accommodation based on his sincerely held religious beliefs. After the Title IX report issued, Dean Milliken informed Meriwether that she was bringing a formal charge against him under the faculty's collective bargaining agreement. She then issued her own report setting forth her findings. Because Dr. Meriwether repeatedly refused to change the way he addressed Doe in his class due to his views on transgender people, And because the way he treated Doe was deliberately different than the way he treated others in class, he effectively created a hostile environment. Milliken's whole explanation of how Meriwether violated university policy spanned just one paragraph. Finally, to create a safe educational experience for all students, Dean Milliken concluded that it was necessary to discipline Meriwether. She recommended placing a formal warning in his file. Provost Jeffrey Bauer was tasked with reviewing Milliken's disciplinary recommendation before it was posed. Meriwether wrote Provost Bauer a letter stating he treated Doe exactly the same as he treated all male students, that he began referring to Doe without pronouns and by Doe's last name as an accommodation to Doe, and that Doe's access to educational benefits and opportunities was never jeopardized. Meriwether further explained that he could not use female pronouns to refer to Doe due to his conscience and religious convictions. He asked Provost Bauer to allow reasonable minds to differ on this newly emerging cultural issue. Provost Bauer rejected Meriwether's request, stating that he approved of Dean Milliken's recommendation of formal disciplinary action. Bauer did not address Meriwether's arguments to the contrary, nor did he grapple with Meriwether's request for religious accommodation. Shawnee State then placed a written warning in Meriwether's file. The warning reprimanded Meriwether and directed him to change the way he addresses transgender students to avoid further corrective actions. What does further corrective actions mean? Suspension without pay and termination, among other possible punishments. The Shawnee State Faculty Union then filed a grievance on Meriwether's behalf. It asked the university to 1, vacate the disciplinary action, and 2, allow Meriwether to keep speaking in a manner consistent with his religious beliefs. Provost Bauer, who had already rejected Meriwether's claim once, was tasked with deciding the grievance. A union representative, Dr. Chip Perot, joined Meriwether to present the grievance at a hearing. From the outset, Bauer exhibited deep hostility. He repeatedly interrupted the representative and made clear that he would not discuss the academic freedom and religious discrimination aspects of the case. The union representative tried to explain the teachings of Meriwether's church and why Meriwether felt he was compelled to affirm a position at odds with his faith. At one point during the hearing, Provost Bauer openly laughed. Indeed, Bauer was so hostile that the union representative was not able to present the grievance. Bauer denied the grievance. The next step in Shawnee State's grievance process involved an appeal to the university's president. In a twist of fate, the president turned out to be Bauer. Shortly after Provost Bauer denied the grievance, he was appointed interim university president. Bauer designated 2 of his representatives, Shawnee State's labor relations director and general counsel, to meet with Meriwether and Perot on his behalf. The officials agreed with the union that Meriwether's conduct had not created a hostile educational environment, but they recommended ruling against Meriwether anyway. This was, they said, not a hostile environment case. Instead, it was differential treatment. This change in theory contradicted the Title IX investigation and Dean Milliken's disciplinary recommendation, which Provost Bauer approved, both of which accused Meriwether of violating university policy by creating a hostile environment for Doe. The officials justified the university's refusal to accommodate Meriwether's religious beliefs by equating his views to those of a hypothetical racist or sexist. Since the university would not accommodate religiously motivated racism or sexism, it ought not to accommodate Meriwether's religious beliefs. Bauer adopted his representative's findings and denied the grievance again. This was the end of the grievance process at Shawnee State. Because Meriwether now fears that he will be fired or suspended without pay if he does not toe the university's line on gender identity, he alleges he cannot address a high-profile issue of public concern that has significant philosophical implications. He steers class discussions away from gender identity issues and has refused to address the subject when students have raised it in class. The warning letter in Meriwether's file will make it difficult, if not impossible, for him to obtain a position at another institution once he retires from Shawnee State. Out of options at Shawnee State, Meriwether filed this lawsuit. He alleged that the university violated his rights under 1, the free speech and free exercise clauses of the First Amendment, 2, the due process and equal protection clauses of the 14th Amendment, 3,
Representative Beber, just 1 second. It's getting a little loud. Could you please hold it down in the chamber? Thank you.
3, the Ohio Constitution, and 4, his contract with the university. The district court referred the case to a magistrate judge. Doe and an organization, Sexuality and Gender Acceptance, then moved to intervene, and the magistrate granted their motion. Next, the defendants and interveners filed separate motions to dismiss under the rule. The magistrate recommended dismissing all of Meriwether's federal claims and declining to exercise supplemental jurisdiction over his state law claims. Meriwether then objected to the magistrate's report and recommendation, but the district court adopted it in full. Meriwether now appeals the court's decision except for its dismissal of his equal protection claim. We must first address Meriwether's free speech claim before turning to his free exercise and due process claims. 2, universities have historically been fierce guardians of intellectual debate and free speech. Speech First, Incorporated v. Schissel. But here, Meriwether alleges that Shawnee State's application of its gender identity policy violated the free speech clause of the First Amendment. The district court rejected this argument and held that a professor's speech in the classroom is never protected by the First Amendment. We disagree. Under controlling Supreme Court and Sixth Circuit precedent, the First Amendment protects the academic speech of university professors. Since Meriwether has plausibly alleged that Shawnee State violated his First Amendment rights by compelling his speech or silence and casting a pall of orthodoxy over the classroom, his free speech may proceed. Start with the basics. The First Amendment protects the right to speak freely and the right to refrain from speaking at all. Thus, the government may not compel affirmance of a belief with which the speaker disagrees. When the government tries to do so anyway, it violates this cardinal constitutional command. It should come as little surprise, then, that prominent members of the founding generation condemned laws requiring public employees to affirm or support beliefs with which they disagreed. Why? Because free speech is essential to our democratic form of government. Without genuine freedom of speech, the search for truth is stymied, and the ideas and debates necessary for the continuous improvement of our republic cannot flourish. Courts have often recognized that the free speech clause applies at public universities. Thus, the state may not act as though professors or students shed their constitutional rights to freedom of speech or expression at the university gate. Government officials violate the First Amendment when they try to prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, and when they force citizens to confess by word or act their faith therein. To be sure, free speech rules apply differently when the government is doing the speaking. And that remains true even when a government employee is doing the talking. Thus, in Garcetti versus Ceballos, the Supreme Court held that normally, when public employees make statements pursuant to their official duties, the employees are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline. Here, the threshold question is whether the rule announced in Garcetti bars Meriwether's free speech claim. It does not. Garcetti set forth the general rule regarding government employees' speech, but it expressly declined to address whether its analysis would apply to a case involving speech related to scholarship or teaching. The plain language of Garcetti thus explicitly left open the question of whether its principles apply in the academic genre where issues of scholarship or teaching are at play. Although Garcetti declined to address the question, we can turn to the Supreme Court's prior decisions for guidance. Those decisions have long recognized that, given the important purpose of public education and the expansive freedoms of speech and the thought associated with the university environment, universities occupy a special niche in our constitutional tradition. Start with Sweezy versus New Hampshire. During the McCarthy era, New Hampshire instituted a loyalty program to eliminate subversive persons among government personnel. The state legislature authorized the Attorney General to become a one-man legislative committee and take appropriate action if he found that a person was subversive. When the Attorney General questioned Public University Professor Paul Sweezy, he declined to reveal the contents of a lecture he had delivered to 100 students in a humanities course. The Attorney General then had the court hold him in contempt. The case ultimately made its way to the Supreme Court, which held that a legislative inquiry into the contents of a professor's lectures unquestionably was an invasion of his liberties in the areas of academic freedom and political expression. The court explained that it could not be seriously debated that a professor's right to lecture is protected by the Constitution, and it emphasized the essentiality of freedom in the community of American universities. When the state targets professors' academic freedom rather than protects it, scholarship, teaching, and education cannot flourish. Political power must abstain from intrusion into the activity of freedom, except for reasons that are exigent and obviously compelling. A decade later, in a case involving a New York law banning subversive activities, the Supreme Court affirmed that the Constitution protects academic freedom, which is of transcendent value to all of us, and not merely to the teachers concerned. It characterized academic freedom as a special concern of the First Amendment, and said that the First Amendment does not tolerate laws that cast a pall of orthodoxy over the classroom. After all, the classroom is peculiarly the marketplace of ideas. And when the state stifles a professor's viewpoint on a matter of public import, much more than the professor's rights are at stake. Our nation's future depends upon leaders trained through wide exposure to the robust exchange of ideas, not through authoritative compulsion of orthodox speech. To impose any straitjacket upon the intellectual leaders in our colleges and universities would imperil the future of our nation. Together, Sweezy and Keishian established the First Amendment, protects the free speech rights of professors when they are teaching. We break no new constitutional ground in reaffirming this nation's dedication to safeguarding academic freedom. First Amendment rights are available to teachers. As a result, our court has rejected as totally unpersuasive the argument that teachers have no First Amendment rights when teaching, or that the government can censor teacher speech without restriction. And we have recognized that a professor's rights to academic freedom and freedom of expression are paramount in an academic setting. Simply put, professors at public universities retain First Amendment protections at least when engaged in core academic functions, such as teaching and scholarship. In reaffirming this conclusion, we join three of our sister circuits, the 4th, 5th, and 9th. In Adams v. Trustees of the University of North Carolina, Wilmington, the 4th Circuit held that Garcetti left open the question whether professors retained academic freedom rights under the First Amendment. It concluded that the rule announced in Garcetti does not apply in the academic context of a public university. The 5th Circuit also held that the speech of public university professors is constitutionally protected, reasoning that academic freedom is a special concern of the First Amendment. Likewise, the 9th Circuit has recognized that if applied to teaching and academic writing, Garcetti would directly conflict with the important First Amendment values previously articulated by the Supreme Court. Thus, it is held that Garcetti does not, indeed consistent with the First Amendment, cannot apply to teaching and academic writing that are performed pursuant to the official duties of a teacher and professor. One final point worth considering. If professors lacked free speech protections when teaching, a university would wield alarming power to compel ideological conformity. A university president could require a pacifist to declare that a war is just, a civil rights icon to condemn the freedom riders, a believer to deny the existence of God, or a Soviet emigre to address his students as comrades. That cannot be. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe such orthodoxy. Shawnee State and the interveners raised several arguments in response. First, they suggest that we ought not apply the Supreme Court's academic freedom cases that preceded Garcetti. But our job as lower court judges is to apply existing Supreme Court precedent unless it is expressly overruled. Agostini v. Felton, and here the Supreme Court has not overruled its academic freedom cases. It is not our prerogative to set this binding precedent aside. Nor is it our prerogative to cast aside our holding that a teacher's in-class speech deserves constitutional protection. Garcetti expressed no view on this issue and even recognized that expression related to classroom instruction might not fit within the court's customary employee speech jurisprudence. Thus, we remain bound by prior Supreme Court and Sixth Circuit precedent in this area. Second, they argue that even if there is an academic freedom exception to Garcetti, it does not protect Meriwether's use of titles and pronouns in the classroom. As they would have it, the use of pronouns had nothing to do with the academic freedom interests in the substance of classroom instruction. But that is not true. Any teacher will tell you that choices about how to lead classroom discussion shape the content of the instruction enormously. That is especially so here because Meriwether's choices touch on gender identity, a hotly contested matter of public concern that often comes up during class discussion in Meriwether's political philosophy courses. Describing gender identity as a controversial and sensitive topic of profound value and concern to the public. By forbidding Meriwether from describing his views on gender identity, even in his syllabus, Shawnee State silenced a viewpoint that could have catalyzed a robust and insightful in-class discussion. Under the First Amendment, the mere dissemination of ideas on a state university campus may not be shut off in the name alone of conventions of decency. Rather, the lesson of Pickering and the court's academic freedom decisions is that the state may do so only when its interest is restricting a professor's in-class speech, and that outweighs his interest in speaking. Remember, too, that the university's position on titles and pronouns goes both ways. By the defendant's logic, a university could likewise prohibit professors from addressing university students by their preferred gender pronouns, no matter the professor's own views. And it could even impose such a restriction while denying professors the ability to explain to students why they were doing so. But that's simply not the case. Without sufficient justification, the state cannot wield its authority to categorically silence dissenting viewpoints. Thus, the academic freedom to Garcetti covers all classroom speech related to matters of public concern, whether that speech is germane to the contents of the lecture or not. The need for the free exchange of ideas in the college classroom is unlike that in any other public workplace settings. And a professor's in-class speech to his students is anything but speech by an ordinary government employee. Indeed, in the college classroom, there are three critical interests at stake, all supporting robust speech protection. One, the student's interested and informed opinion. Two, the professor's right to disseminate his own opinion. And three, the public's interest in exposing our future leaders to different viewpoints. Because the First Amendment must always be applied in light of the special characteristics of the environment in the particular case, public universities do not have a license to act as classroom thought police. They cannot force professors to avoid controversial viewpoints altogether in deference to a state-mandated orthodoxy. Otherwise, our public universities could transform the next generation of leaders into closed-circuit recipients of only that which the state chooses to communicate. Thus, what constitutes a matter of public concern and what raises academic freedom concerns is of essentially the same character. Of course, some classroom free speech falls outside the exception. A A university might, for example, require students to call roll at the start of class, and that type of non-ideological ministerial task would not be protected by the First Amendment. Shawnee State says that the rule at issue is similarly ministerial. But as we discussed below, titles and pronouns carry a message. The university recognizes that and wants its professors to use pronouns to communicate a message. People can have a gender identity inconsistent with their birth. But Meriwether does not agree with that message, and he does not want to communicate it to his students.
Sorry,
That's not a matter.
Representative Van Beber, just 1 second. Members, could you please take your conversations off to the side? It's getting pretty loud in here again. Go ahead, continue. Representative Van Beber, continue.
Thank you. That's not a matter of classroom management. That's a matter of academic speech. Finally, defendants argue that academic freedom belongs to public universities, not professors. But we've held that university professors have First Amendment rights when teaching that they may assert against the university, so this argument fails. Although Garcetti does not bar Meriwether's free speech claim, that is not the end of the matter. We must now apply the longstanding Pickering-Connick framework to determine whether Meriwether has plausibly alleged that his in-class speech was protected by the First Amendment. Under that framework, we ask two questions. First, was Meriwether speaking on a matter of public concern? And second, was his interest in doing so greater than the university's interest in promoting the efficiency of the public services it performs through him? To determine whether speech involves a matter of public concern, we look to the content, form, and context of a given statement, as revealed by the whole record. When speech relates to any matter of political, social, or other concern to the community, it addresses a matter of public concern. Thus, a teacher's in-class speech about race, gender, and power, conflicts addresses matters of public concern. A basketball coach using racial epithets to motivate his players does not. The linchpin of this inquiry is, thus, for both public concern and academic freedom, to the extent to which the speech advances an idea transcending personal interest or opinion, which impacts our social and/or political lives. Meriwether did just that in refusing to use gender identity-based pronouns. And the point of his speech, or his refusal to speak in a particular manner, was to convey a message. Taken in context, his speech concerns a struggle over the social control of language in a crucial debate about the nature and foundation, or indeed real existence, of the sexes. That is, his mode of address was the message. It reflected his conviction that one's sex cannot be changed, a topic which has been in the news on many occasions and has become an issue of contentious political debate. From courts to schoolrooms, this controversy continues. Recently, the Fifth Circuit rejected an appellant's motion to be referred to by the appellant's preferred gender pronouns over an emphatic dissent. And on the other side, a Texas high school generated controversy when it permitted its students to display preferred gender pronouns on their online profiles. Further examples abound. In short, the use of gender-specific titles and pronouns has produced a passionate political and social debate. All this points to one conclusion. Pronouns can and do convey a powerful message implicating a sensitive topic of public concern. The history of pronoun usage in American discourse underscores this point. Following the 1745 publication of Anne Fisher's A New Grammar, the idea that he, him, and his should go both ways caught on and was widely adopted. But in the latter half of the 20th century, gendered pronouns became imbued with new meaning. The feminist movement came to view the generic use of masculine pronouns as a crucial mechanism for the conceptual invisibility of women. It regarded the generic masculine pronoun as rooted in pre-existing cultural prejudice and subtly influencing our perceptions and recirculating the sexist prejudice. As a result, feminist attempts at language reform served as a means for sensitizing individuals to which language is discriminatory towards women. To the feminist cause, pronouns mattered. and history tends to repeat itself. Never before have titles and pronouns been scrutinized as closely as they are today for their power to validate or invalidate someone's perceived sex or gender identity. Merriweather took a side in that debate. Through his continued refusal to address Doe as a woman, he advances a viewpoint on gender identity. Merriweather's speech manifested his belief that sex is fixed in each person from the moment of conception, and that it cannot be changed regardless of an individual's feelings or desires. The focus, point, intent, and communicative purpose of the speech in question was a matter of public concern. And even the university appears to think this pronoun debate is a hot issue. Otherwise, why would it forbid Merriweather from explaining his personal and religious beliefs about gender identity in his syllabus? No one contests that what Merriweather proposed to put in his syllabus involved a matter of public concern. Holding that free speech was later unable to make touched on a matter of public concern. In short, when Merriweather waded into the pronoun debate, he waded into a matter of public concern. Because Merriweather was speaking on a matter of public concern, we apply Pickering balancing to determine whether the university violated his First Amendment rights. This test requires us to arrive at a balance between the interests of the professor as a citizen in commenting upon matters of public concern and in the interest of the state, as an employer in promoting the proficiency of the public services it performs through its employees. Hence, that balance favors Merriweather. Start with Merriweather's interests. We begin with the robust tradition of academic freedom in our nation's post-secondary schools. That tradition alone offers a strong reason to protect Professor Merriweather's speech. After all, academic freedom is a special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classroom. And the First Amendment interests are especially strong here because Merriweather's speech also relates to his core religious and philosophical beliefs. Finally, this case implicates an additional element, potentially compelled speech on a matter of public concern. And when speech is compelled, additional damage is done. Those interests are powerful. Here, the university refused even to permit Merriweather to comply with its pronoun mandate while expressing his personal convictions in a syllabus disclaimer. That ban is anathema to the principles underlying the First Amendment. As the proudest boast of our free speech jurisprudence is what we protect the freedom to express the thought that we hate. Indeed, the premise that gender identity is an idea embraced and advocated by increasing numbers of people is all the more reason to protect the First Amendment rights of those who wish to view and voice a different view. And this is particularly true in the context of the college classroom, where students' interest in hearing even contrarian views is also at stake. Teachers and students must also remain free to inquire, to study, and to evaluate, to gain new maturity and understanding. On the other side of the ledger, Shawnee State argues that it has a compelling interest in stopping discrimination against transgender students. There, a panel of our court held that an employer violates Title VII when it takes an adverse employment action based on an employee's transgender status. The panel did not hold, and indeed consistent with the First Amendment, could not have held, that the government always had a compelling interest in regulating employees' speech on matters of public concern. Doing so would reduce Pickering to a shell, and it would allow universities to discipline professors, students, and staff anytime their speech might cause offense. This is not the law. The public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some of the hearers. Purportedly, neutral non-discrimination policies cannot be used to transform institutions of higher learning into enclaves of totalitarianism. Turning to the facts, the university's interest in punishing Merriweather's speech is comparatively weak. When the university demanded that Merriweather refer to Doe using female pronouns, Merriweather proposed a compromise. He would not call on Doe using Doe's last name alone. This seemed like a win-win. Merriweather would not have to violate his religious beliefs, and Doe would not be referred to using pronouns Doe finds offensive. Thus, on the allegations in this complaint, it is hard to see how this would have created a hostile learning environment that ultimately thwarts the academic process. It is telling that Dean Milliken at first approved this proposal, and when Meriwether employed this accommodation through the semester, Doe was an active participant in class and ultimately received a high grade. As we stated in Hardy, a school's interest in limiting a teacher's speech is not great when those public statements are neither shown nor can be presumed to have in any way either impeded the teacher's proper performance of his daily duties in the classroom or to have interfered with the regular operations of the schools generally. The mere fear of apprehension of disturbance is not enough to overcome the right of freedom of expression. At this stage of the litigation, there is no suggestion that Meriwether's speech inhibited his duties in the classroom, hampered the operation of the school, or denied Doe any educational benefits. Without such a showing, the school's actions mandate orthodoxy is not anti-discrimination and ignore the fact that tolerance is a two-way street. Finally, Shawnee State and the interveners argue that Title IX compels a contrary result. We disagree. Title IX prohibits discrimination under any education program or activity based on sex. The requirement that the discrimination occur under any education program or activity suggests that the behavior must be serious enough to have the systemic effect of denying the victim equal access to an educational program or activity. But Meriwether's decision not to refer to Doe using feminine pronouns did not have any such effect. As we have already explained, there is no indication at this stage of the litigation that Meriwether's speech inhibited Doe's education or ability to succeed in the classroom. Holding that Title IX's hostile environment claim requires that one's educational experience be permeated with discriminatory intimidation, ridicule, and insult that is sufficiently severe or persuasive so as to alter the condition of the victim's educational environment. Bauer even admitted that Meriwether's conduct was not so severe and persuasive that it created a hostile educational environment. Thus, Shawnee State's purported interest in complying with Title IX is not implicated by Meriwether's decision to refer to Doe by name rather than Doe's preferred pronouns. In sum, the founders of this nation believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. Shawnee State allegedly flouted that core principle of the First Amendment. Taking the allegations as true, we hold that the university violated Meriwether's free speech rights. Meriwether next argues that as a public university, Shawnee State violated the Free Exercise Clause when it disciplined him for not following the university's pronoun policy. We agree. The Constitution requires that the government commit itself to religious tolerance. Thus, laws that burden religious exercise are presumptively unconstitutional unless they are both neutrally and generally applicable. To determine whether a law is neutral, courts must look beyond the text and scrutinize the history, context, and application of a challenged law. In this way, the Free Exercise Clause guards against even subtle departures from neutrality on matters of religion. Meriwether has plausibly alleged that Shawnee State's application of its gender identity policy was not neutral for at least two reasons. First, officials at Shawnee State exhibited hostility to his religious beliefs. And second, irregularities in the university's adjudication and investigation processes permit a plausible inference of non-neutrality. State actors must give neutral and respectful consideration to a person's sincerely held religious beliefs. When they apply an otherwise neutral law with religious hostility, they violate the Free Exercise Clause. In this case, the pleadings give rise to a sufficient suspicion of religious animosity to warrant pause for discovery. Meriwether was entitled to a neutral decision maker who would give full and fair consideration to his religious objection as he sought to assert it in all of the circumstances in which this case was presented, considered, and decided, and that he at least plausibly did not receive. Start with one of the individuals Meriwether alleges was involved in the action against him, Department Chair Jennifer Talley. Meriwether came to her to discuss his religious concerns about the new policy. Talley might have responded with tolerance or at least neutral objectivity. She did not. Instead, she remarked that religion oppresses students and said that even its presence at universities is counterproductive. Christians in particular, she said, were primarily motivated out of fear. In her view, Christian doctrines should not be taught. And for good measure, she added that Christian professors should be banned from teaching courses on Christianity, knowing that Meriwether had done so for decades. Neutral and non-hostile, as alleged, no. In fact, it has the makings of the very religious intolerances that gave concern to those who drafted the Free Exercise Clause. So what does the university say about these statements? It claims that Talley was not involved in formulating, interpreting, or applying the university's gender identity policy, and that she was not involved in the action against him. Maybe so. But at the motion to dismiss stage, courts must accept the allegations as true, and here, the complaint alleges that Talley was involved. And Talley was not the only allegedly hostile actor. After Meriwether was disciplined, a union representative presented Meriwether's grievance to Provost Bauer, a supposedly neutral adjudicator. But Bauer did not seem so neutral. He repeatedly interrupted the union representative and made clear that he would not discuss the academic freedom and religious discrimination aspects of the case. The union representative tried to explain Meriwether's religious beliefs and the teachings of his church, but Provost Bauer responded with open laughter. And after the laughter, Bauer became so uncooperative that the union representative was not able to present the grievance at all. Bauer's alleged actions and words demonstrated anything but the neutral and respectful consideration that the Constitution demands. Shawnee's State Director of Labor Relations, Bauer's representative, then piled on when he reviewed the grievance. In his view, Meriwether's convictions were no better and no more worthy of tolerant accommodation than religiously motivated racism or sexism. Bauer adopted this reasoning in denying Meriwether's grievance once again. If this sounds familiar, it should. In Masterpiece Cake Shop, the Supreme Court reversed a decision of the Colorado Civil Rights Commission when the commission made hostile statements that cast doubts on the fairness of the adjudication. The commission had said that religion has been used to justify all kinds of discrimination throughout history, suggesting that the defendant was using religion as a pretext for discrimination. The Supreme Court called such comments inappropriate and said they called the commission's impartiality into question. That same rationale applies here. Meriwether respectfully sought an accommodation that would both protect his religious beliefs and make Doe comfortable. In response, the university derided him and equated his good faith convictions with racism. An interference of religious hostility is plausible in these circumstances. In sum, Meriwether has plausibly alleged that religious hostility infected the university's interpretation and application of its gender identity policy. Whether this claim ultimately prevails will depend on the results of discovery and the clash of proofs at trial. For now, we simply hold that Meriwether had plausibly alleged a free exercise claim based on religious hostility. While the hostility Shawnee State exhibited would be enough for Meriwether's claim to survive a motion to dismiss, Meriwether has more. He alleges that various irregularities in the university's investigation and adjudication processes also permit an interference of non-neutrality. We agree. Not all laws that look neutral and generally applicable are constitutional. The Free Exercise Clause forbids subtle departures from neutrality and covert suppression of particular religious beliefs. Thus, courts have an obligation to meticulously scrutinize irregularities to determine whether a law is being used to suppress religious beliefs And here, that scrutiny reveals signs of non-neutrality. First, the university's alleged basis for disciplining Merriweather was a moving target. The Title IX report claimed that Merriweather violated the university's gender identity policy by creating a hostile educational environment. Dean Milliken agreed and recommended disciplining Merriweather for this hostile environment. Yet when Merriweather grieved his discipline, university officials conceded that Merriweather had never created a hostile environment. Instead, they said the case was about disparate treatment. But at oral argument, the university changed its position once again. It said that this really is a hostile environment case. These repeated changes in position, along with the alleged religious hostility, permit a plausible inference that the university was not applying a pre-existing policy in a neutral way, but was instead using an evolving policy as pretext for targeting Merriweather's beliefs. And it is also plausible that the reinterpretation of the policy was an after-the-fact invention designed to justify punishing Merriweather for his religiously motivated speech, not a neutral interpretation of a generally applicable policy. Second, the university's policy on accommodations was a moving target. Why does this matter? Because when individualized exemptions from a general requirement are available, the government may not refuse to extend that system to cases of religious hardship without compelling reason. When Dean Milliken told Merriweather that he was violating the university's gender identity policy, Merriweather proposed a compromise. He would address Doe using Doe's last name and refrain from using pronouns to address Doe. Dean Milliken accepted this accommodation, but several weeks later she retracted the agreed-upon accommodation and demanded that Merriweather use Doe's preferred pronouns if he intended to use pronouns to refer to other students. Now the university claims that its policy does not permit any religious accommodations. This about-face permits a plausible inference that the policy allows accommodations, but the university won't provide one here. If this inference is supported through discovery and trial, a jury could conclude that the university's refusal to stick to its accommodation is pretext for punishing Merriweather's religious views and speech. Third, the university's Title IX investigation raises several red flags. On their own, these issues might not warrant an inference of non-neutrality, but combined with other allegations in the complaint, they provide probative circumstantial evidence of discrimination. For starters, the Title IX investigator interviewed just 4 witnesses, including Merriweather and Doe. She did not interview a single non-transgender student in any of Merriweather's classes, nor did she ask Merriweather to recommend any potential witnesses. Indeed, except for Merriweather and Doe, not a single witness testified about any interactions between the two. Even so, the Title IX officer concluded that Merriweather created a hostile environment. Under the university's policies, a hostile environment exists only when there is harassing conduct that limits, interferes, or denies educational benefits or opportunities from both the subjectives, the complainants, and an objective, reasonable person's viewpoint. But the Title IX report does not explain why declining to use a student's preferred pronouns constitutes harassment. It does not explain how Merriweather's conduct interfered with or denied Doe or Doe's classmates any educational benefits or opportunities, let alone how an objective observer could reach such a conclusion. And it does not grapple with Merriweather's request for an accommodation based on his sincerely held religious beliefs. In short, the university's cursory investigation and findings provide circumstantial evidence of subtle departures from neutrality. And this suggests that the neutral consideration to which Merriweather was entitled was compromised here. The university raises several counter-arguments, none of which we find persuasive. First, the university seems to suggest that compliance with non-discrimination laws can never burden an individual's religious beliefs under our holding in Harris Funeral Homes. If that is their argument, it mischaracterizes the case. In Harris, a panel of our court held that Title VII prevented an employer from firing a transgender employee because of the employee's transgender status. The employer believed that the law burdened the free exercise of his religion because he would have to endorse the immutability of sex to comply. The panel explained that even if the belief were sincere, that did not resolve the question. And ultimately, the panel determined that compliance with Title VII did not burden the employer's religious beliefs because requiring the employer to refrain from firing an employee with different views does not, as a matter of law, mean that the employer is endorsing or supporting those views. As the university would have it, that means that compliance with a non-discrimination law can never amount to a coerced endorsement of contrary religious views. That is not what we said, and that is not the law. Depending on the circumstances, the application of a non-discrimination policy could force a person to endorse views incompatible with his religious convictions, and a requirement that an employer not fire an employee for expressing a transgender identity is a far cry from what we have here. A requirement that a professor affirmatively change his speech to recognize a person's transgender identity. The university itself recognizes that Harris was careful not to require an endorsement regarding the mutability of sex. Remember, too, that Meriwether proposed a compromise. He would consider referring to students according to their self-asserted gender identity if he could also include a note in the syllabus about his religious beliefs on the issue. The university said no. Meriwether would violate the policy even by disclaiming a belief in transgender identity. It cannot now argue that the policy did not require Meriwether to endorse a view on gender identity contrary to his faith. Next, the interveners submit that because Milliken issued the written warning and because there is no allegation that Milliken harbored any animus towards plaintiff's religious beliefs, Meriwether's free exercise claim must fail. Why? Because the original disciplinary decision was not the product of animus. But that argument is both factually and legally flawed. According to the facts in the complaint, Milliken did not issue the warning. She recommended it. But Bauer imposed the punishment and notified Meriwether of it. And in any case, Masterpiece forecloses this argument. A disciplinary proceeding that is fair at the beginning still violates the free exercise clause if it is influenced by religious hostility later. In Masterpiece, the Colorado Civil Rights Division, like Milliken, first found probable cause that Phillips violated the Colorado Anti-Discrimination Act and referred the case to the Civil Rights Commission. Neither the Civil Rights Division nor the ALJ exhibited any hostility, but the commission was hostile, and that was enough. It doesn't matter that some stages of a proceeding are fair and neutral if others are not. What matters is whether unconstitutional animus infected the proceedings. Finally, the university argues that Meriwether simply could have complied with the alternative it offered him. Don't use any pronouns or sex-based terms at all. This offer, the university says, would not violate Meriwether's religious beliefs. But such an offer has two problems. First, it would prohibit Meriwether from speaking in accordance with his belief that sex and gender are conclusively linked. And second, such a system would be impossible to comply with, especially in a class-heavy discussion and debate. We're stopping right there. No, Mr. and Mrs., no yes, sir, or no, ma'am, no he said or she said. And when Meriwether slipped up, which he inevitably would, especially after using these titles for 25 years, he could face discipline. Our rights do not hinge on such a precarious balance. The effect of this Hobson's choice is that Meriwether must adhere to the university's orthodoxy or face punishment. This is coercion, or at the very least, of the indirect sort. And we know the free exercise clause protects both direct and indirect coercion. The proposition is that the law does not interfere with free exercise because it does not directly prohibit religious activity, but merely conditions eligibility for office on its abandonment, and that is squarely rejected by precedent. Simply put, the alternative the university offered does not save its policy. For the reasons just explained, Meriwether has plausibly alleged that Shawnee State burdened its free exercise rights. Thus, we apply the most rigorous of scrutiny to the university's actions. We uphold them only if they advance interests of the highest order and are narrowly tailored in pursuit of those interests. The university does not even argue that its application of this policy meets this standard. Thus, we hold that Meriwether's free exercise claim may proceed.
Representative Baisley.
Thank you, Madam Chair. So that was an awful lot of words from our colleague from Weld County, but let me put the fine point on this, if I may, as it applies to this amendment. As we contemplate in this body law, new Colorado state statute that would compel speech, the people to whom these laws would apply, which would be virtually all of us, need to also get that assurance from us that we recognize and will diligently uphold their First Amendment, United States constitutional First Amendment right to free speech. That's the intent of this amendment, and I think it's critically important that we not overstep our role, that we not scare people by the force of law, because that's what we do is we make law, and law is force in government, and they need to not have fear of what they say, but understand that while we all need to have our sensitivities and our love for one another, our acceptance of one another, we need not be in fear for our speech, which is protected by the First Amendment of the United States Constitution. Longstanding, extremely important. So that's the purpose of this amendment, and I would urge a yes vote.
Any further discussion on the amendment? Representative Carver.
Thank you, Madam Chair, and I just have a few concluding remarks. A very important case in 2006, really with Rumsfeld versus Forum for Academic and Institutional Rights. And Chief Justice Roberts wrote the majority opinion, but he used that opinion to really lay out the case on the importance of the First Amendment's protection against compelled speech. And we just heard a case that came out just days ago, addressing First Amendment protection and how that includes that the government in its actions, including a university, cannot force an orthodoxy of thought, statement, etc., to the extent that it results in compelled speech. And so Chief Justice Roberts in this 2006 case had this to say: our compelled speech cases are not limited to the situation in which an individual must personally speak the government's message. We have also a number of instances limited the government's ability to force one speaker to host or accommodate another speaker's message. And then it goes on to list a series of cases where the government, in either requirements for certain parades that were held annually, and utilities that have to include certain messaging. But the point of that statement is compelled speech is not just focusing on government forcing one to adopt or sponsor or accommodate or echo what the government says is the right speech. The compelled speech cases also prohibit the government in saying one private speaker can force another private speaker in a compelled speech situation. And so it is critically important, and members, may I just remind you, we are talking about an amendment to the legislative declaration. That's what we're talking about. And I don't understand why there is objection to simply recognizing in the legislative declaration an amendment that says your First Amendment rights in freedom of speech, to include restrictions on compelled speech, recognizing that speech can be statement, conduct, artistic expression, etc., not defined by me, defined by the Supreme Court. That we recognize and will uphold those constitutional principles in how this law is implemented. That's all this amendment does. That's all these cases speak to. And so I don't understand why there is objection to that. And finally, I'm going to end just with some great language from Justice Kennedy in the Becerra case, which came out in 2018. And this is where the state of California required that certain notices be posted on privately operated pregnancy centers, pro-life pregnancy centers, on the availability of abortion services in the state. And Kennedy wrote, "It does appear that viewpoint discrimination is inherent in the design and structure of this act. This law is a paradigmatic example of the serious threat presented when government seeks to impose its own message in place of individual speech, thought, and expression. For here, the state requires primarily pro-life pregnancy centers to promote the state's own preferred message, advertising abortions. This compels individuals to contradict their most deeply held beliefs, beliefs grounded in basic philosophies, ethical or religious precepts, or all of the above. And the history of the Act's passage and its under-inclusive application suggests a real possibility that these individuals were targeted because of their beliefs." Members, I'll wrap my comments up now, and I am simply trying to put in the record the full scope of the constitutional safeguards that are in play in 2021, as they have been throughout the decades. Yes, in a new context, as we heard in the case that came out just a few days ago. And that's all we're doing in this amendment, is recognizing those fundamental principles. And with that, I would ask for an aye vote on the amendment.
Any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L006. All those in favor say aye. Aye. All those opposed, no. No. The amendment is lost. To the bill, any further discussion? Representative Luck.
Thank you, Madam Chair. As legislators, our constant job is balancing interests. And sometimes those interests are few and easy to balance. And sometimes, like in this case, they're many and they're much more challenging to balance. CATA is an act related to our identity. And as such, it causes a lot of emotion, it causes a lot of reflection, it causes a lot of thought. How do we balance each other's identities in a way that is honorable to all? What does that look like? I believe, and I'm not sure, but I believe that is the heart of the sponsor of this bill, to seek to have our identities all honored within the law. This becomes a challenge, though, when one defines their identity in terms that present a conflict to the way someone else defines their identity. And then the question becomes for us as the state which is supposed to be neutral, the state which is supposed to be a referee, an arbiter of rights, a definer of boundaries, an ensurer of protection. How do we resolve those conflicts? What does that look like? I mean, that is the question that is before us. How do we resolve those conflicts? This is a question that our society has been having for over a decade on the question of sexual orientation, for much longer on questions otherwise identified in CATA. And I don't know that we are really any closer to finding a solution that genuinely balances all of those rights, not creating one higher than the other. But I think that is what we need to continue to pursue. And so as a result, I would like to move Amendment L018. Similar to my colleague, Representative Carver, who wanted to carve out and ensure the protection that the First Amendment already affords was restated in this bill. I am seeking to expand the definition of religious organization as defined in our place of public accommodation statute for the purpose of reaffirming current First Amendment jurisprudence as relates to the Establishment Clause and the Free Exercise Clause, because this introduction of new definitions of gender identity and gender expression, the way that we are defining it, will impact a variety of religious nonprofits in very unique ways. And so I think, again, going back to that balancing test, how do we balance all of the respective interests? I think just reaffirming, again, what the Supreme Court has already decided on a number of topics, what other circuit courts have already decided on a number of topics as relates to the First Amendment and religious freedom. I submit this amendment. Thank you.
Any further discussion on amendment, Representative Sanders?
Thank you. I stand in support of this amendment. And what I'm going to do is, people have brought up Jack Phillips and the Masterpiece Cake Shop suits. I think a lot of us, and this is associated with this amendment, a lot of us aren't really familiar with that. I think there's some misunderstandings. So what we're going to do is we're going to discuss the associated with this amendment, the complaint. And so make sure everybody is aware of the specific facts of this, why the complaint was brought forward, and why ultimately the Supreme Court voted in favor of Masterpiece Cake Shop. So let me get started. In the United States District Court for the District of Colorado, Masterpiece Cake Shop Incorporated, a Colorado corporation, and Jack Phillips versus Director of Colorado Civil Rights Division, and it lists members of the Civil Rights Division, as well as Cynthia Kaufman. Thank you. Who was the Colorado Attorney General at that time, and John Hickenlooper, who was a governor at that time. Introduction. The U.S. Constitution stands as a bulwark against state officials who target people and seek to ruin their lives. Because of the government's anti-religious anonymous, for over 6 years now, Colorado has been on a crusade to crush plaintiff Jack Phillips because its officials despise what he believes, and how he practices his faith. After Phillips defended himself all the way to the U.S. Supreme Court and won, he thought Colorado's hostility towards his faith was over. He was wrong. Colorado has renewed its war against him by embarking on another attempt to prosecute him. In direct conflict with the Supreme Court's ruling in his favor, this lawsuit is necessary to stop Colorado's continuing persecution of Phillips. Phillips is a Christian, an expert cake artist who owns and operates a small family business, Plaintiff Masterpiece Cake Shop Incorporated. Both Phillips and Masterpiece Cake Shop serve everyone, all people, no matter who they are, what they believe, or what protected characteristics they have, are welcome to Phillips' shop and may purchase anything available for sale. But as a devout man of faith, Phillips cannot create custom cakes that express messages or celebrate events in conflict with his religious beliefs. When a customer asks him to create such a cake, he cannot do so, no matter who requests it. On the other hand, when someone asks Phillips to design a cake expressing a message or celebrating an event that is not contrary to his faith, he will create it, no matter who requests it. For exercising his faith this way, Colorado has doggedly pursued Phillips, turning his life upside down. It started when Phillips declined to create a custom wedding cake celebrating a view of marriage that conflicts with his faith teachings. Colorado punished Phillips for that, while allowing other cake artists, those whose views the state likes, to refuse to create cakes with a message they deem objectionable. Making matters worse, state officials publicly compared Phillips' religious exercise to defense of slavery and the Holocaust, a deeply offensive accusation against a man whose father helped liberate a concentration camp in World War II. To punish Phillips, Colorado mandated that he implemented coercive staff re-education to teach him and his employees, most of whom are his family members, that it is wrong for him to operate his business according to his faith. The state also ordered him to either violate his religious beliefs or shut down his wedding cake business. Because Phillips could not turn his back on his faith, he was forced to give up that part of his work, which cost him and his family 40% of their income and caused more than half of his employees to lose their jobs. Phillips also endured death threats and countless hateful phone calls, and emails. Venomous treatment that escalated with each new wave of media attention. It got so bad that Phillips' wife was afraid to set foot in their family's own shop. After 6 grueling years, the Supreme Court vindicated Phillips in a 7-2 decision. It declared that Colorado acted with clear and impermissible hostility towards his sincere religious belief. The Supreme Court held that the state manifested its anti-religious hostility towards Phillips' religion, describing it as despicable and enforcing a double standard, enforcing a double standard that harshly punishes Phillips while exonerating other cake artists who similarly declined requests for cakes with messages they deemed objectionable. In the meantime, some Colorado citizens, emboldened by the state's prosecution of Phillips, have targeted him. On the same day that the Supreme Court announced it would hear Phillips' case, a Colorado lawyer called his shop and requested a cake designed with a blue exterior and pink interior, which a caller said would visually depict and celebrate a gender transition. Throughout the next year, Phillips received other requests for cakes celebrating Satan, featuring satanic symbols, depicting sexually explicit materials, and promoting marijuana use. Phillips believes that some of those requests came from the same Colorado lawyer. Phillips declined to create the cake with blue and pink design because it would have celebrated messages contrary to his religious belief that sex, the statute of being male or female, is given by God. It is biologically determined, is not determined by perceptions or feelings, and cannot be chosen or changed. In a mere 24 days after Phillips prevailed in the Supreme Court, Colorado told him that he violated Colorado law by declining to create that cake. In so doing, the state was back on what it told the Supreme Court in its masterpiece briefing, that its public accommodations law allows Phillips to decline to create cakes with pro-LGBT designs and themes. And by citing the masterpiece decision as support for the state's renewed efforts to harass Phillips, Colorado ignored the Supreme Court's numerous references to the state's anti-religious bias and hostility. It is now clear that Colorado will not rest until Phillips either closes Masterpiece Cake Shops or agrees to violate his religious beliefs. The state's continuing effort to target Phillips do not just violate the Constitution, they cross a line into bad faith. The court should now put a stop into Colorado's unconstitutional bullying. Jurisdiction and venue. The Civil Rights Action raises federal questions under the First and 14th Amendment of the United States Constitution and Civil Rights Act. The court has original jurisdiction. The court has authority to award the requested declaration belief. The Federal Court Rule of Civil Procedures 57, the requested injunction belief under 28, and the Federal Rule of Civil Procedure 65. Plaintiffs demand a jury trial on the claims raised in this complaint. Plaintiff Jack Phillips is a Christian who bases his beliefs on the Bible. He resides in Colorado and is a citizen of the United States of America. Together with his wife, he owns and operates Masterpiece Cake Shop Incorporated. Masterpiece Cake Shop is a for-profit corporation formed under Colorado law. Masterpiece Cake Shop's principal place of business is located in Colorado. Defendant Aubrey Ellenis is the director of the Colorado Civil Rights Division and has the authority under Colorado. Additional defendants, commissioners, attorney general, and Governor John Hickenlooper at that time. Statement of facts. Colorado's Anti-Discrimination Act makes it unlawful for a person directly or indirectly to refuse, withhold from, or deny to an individual or group because of their creed, sex, sexual orientation, the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of a place of public accommodation. The law defines person as one or more individuals, limited liability companies, partnerships, associations, corporations, legal representatives, etc. The law defines place of public accommodation as any place of business engaged in any sales of the public and any place offering services, facilities, privileges, advantages, and accommodations to the public, including not limited to any business offering wholesale or retail sales to the public. Colorado considers Masterpiece Cake Shop a place of public accommodation under Colorado revised statute. The public accommodation law defines sexual orientation as an individual's orientation toward heterosexuality, homosexuality, bisexuality, or transgender status, or another individual perception thereof. The law accepts some organizations from its requirements, exempts some organizations from its requirements. For example, it does not apply to a church, synagogue, mosque, or other place that is principally used for religious purposes. The law does not define place that is principally used for religious purposes. The public accommodation law allows a person to make some distinctions based on protected characteristics. For instance, it allows a person to restrict admission to a place of public accommodation to individuals of one sex if such restrictions has a bona fide relationship to the goods, services, facilities, privileges, advantages, or accommodations of a place of public accommodation. The law created the Colorado Civil Rights Division to help implement its requirements. The executive director of the Colorado Department of Regulatory Agencies has the power and duty to appoint a director of the Colorado Civil Rights Division. The executive director of the Colorado Department of Regulatory Agencies shall give good faith consideration to the recommendations of the commission before appointing the director. The director has the power and duty to appoint investigators and other personnel to carry out the functions and duties of this division. The director also has the power and duty to receive, investigate, and make determinations on charges, allegations, unfair, or discriminatory practices in violation of the public accommodation law. The public accommodation law also created the Public Civil Rights Commission within the Division of Colorado Revenue Statute, blah, blah, blah. The commission includes 7 members appointed by the governor with the consent of the Senate in terms of for 4 years. The commission has a power and duty to adopt, publish, amend, and rescind rules to help implement the public accommodation law. The commission has a power and duty to investigate and study the existence, character, causes, and extent of unfair discriminatory practices, and to formulate plans for the elimination of those practices by educational or other means. The commission has a power and duty to hold hearings upon any complaint issued against a respondent, to subpoena witnesses and compel their attendance, to administer oaths and take testimony, and to compel a respondent to produce for examination any books, papers about matters of the complaint. The commission, a commissioner, the attorney general, or any person claiming to be aggrieved by a discriminatory or unfair practice may file a charge alleging a discriminatory or unfair practice with the division. When the division receives a charge, it must first notify the respondent for the charges filed against him or her. The director must then make a prompt investigation of the charge. To support the director's investigation, she may subpoena witnesses, compel testimony, and order the production of books, papers, and records about matters in the charge. After completing the director's investigations, she must determine as promptly as possible whether probable cause exists for crediting the allegations of the charge. At all times, the division and the director must presume that the conduct of any respondent is not unfair or discriminatory until proven otherwise. If the director finds probable cause, she must serve the respondent with a written notice stating that specifically the legal authority and jurisdiction of the communication and the matters of fact and law asserted. The director must also order the charging party and the respondent to participate in compulsory mediation. At that point, the director must endeavor to eliminate the discriminatory or unfair practice by conference. If the director fails to settle the matter, she must report this to the commission. The commission then receives or reviews the matter, and if the commission determines that the circumstance warrant shall issue a written notice and complaint requiring the respondent to answer the charges at a formal hearing before the commission, a commissioner, or at an administrative law judge hearing. At all times, the commission must presume that the conduct of any respondent is not unfair or discriminatory until proven otherwise. At the hearing, the commission's attorney or agent must present the case in support of the complaint. If the commission or its assigned decision maker concludes that a respondent has engaged in or is engaging in any discriminatory or unfair practice, the commission must order the respondent to cease and desist from the activity, to take such action as it may order, consistent with the Public Accommodations Law. The commission has used its power to order business owners, including Phillips, to change their practices, to implement comprehensive re-education programs, and to report the commission every declined order. Any party who disagrees with the commission's final order may abstain judicial review by filing an action in the Colorado Court of Appeals. The commission's fact-finding shall be conclusive if supported by the substantial evidence. The division and the commission interpret and apply Colorado's Public Accommodations Law. Colorado claims the power to use its public accommodation law to compel the speech of people who earn a living creating and selling expression. It believes that the U.S. Constitution, including the First Amendment, provides no protection against the state's use of its public accommodations law to compel the speech of expressive business owners like Phillips. To make that extreme view seems more acceptable, Colorado has announced the general rule that expressive business owners, including cake artists, do not violate the public accommodations law if they decline to create a custom item expressing a message that they would not communicate for themselves. In the Masterpiece case, Colorado told the Supreme Court how the general rule applies to cake artists. Colorado said that it allows cake artists to decline to create custom cakes featuring pro-LGBT themes or symbols if a cake artist would not sell a cake with a particular artistic theme, such as a cake featuring a symbol of gay pride, to any customer regardless of that customer's protected characteristics. He needs to sell one to anyone. Colorado further explained that it allows cake artists to decline to create custom cakes with pro-LGBT designs and messages. Under the Act, a cake artist is free to decline to sell cakes with pro-gay designs or inscriptions. And Colorado announced that it allows cake artists to decline to create custom cakes that they consider offensive. Businesses are entitled to reject orders because they deem a particular product requested by a customer to be offensive. Colorado applied these principles when William Jack, a man who identifies as a Christian, filed discrimination charges against 3 cake shops. Accusar Bakery, La Bakery Central, and actually, that's the third one right there. All 3 of these complaints are out of similar facts. William Jack asked each cake shop to provide quotes for 2 cakes expressing his religious beliefs against same-sex marriage. William Jack asked the cake shops to make cakes that looked like Bibles, that bore an image depicting 2 groomsmen covered with a red X. And that included Bible verses conveying the religious biases for his opposition of same-sex marriage. The cake shops refused to make those cakes because their owners objected to those cakes' messages and would not create them for anyone. William Jack then filed with the division a discrimination charge against each of the cake shops, alleging that they discriminated against him based on his creed in violation of Colorado statute. The commission defines creed as all aspects of religious beliefs, observations and practices, as well as sincerely held moral and ethical beliefs as to what is right and what is wrong. Ultimate ideas or questions regarding the meaning of existence and the beliefs of teaching of a particular religion, church, denomination, etc. After completing its investigation, the division issued determinations finding no probable cause for each of these complaints, even though the cake shop refuses a religious person's request to create cakes that express religious beliefs. The division made these determinations because the requested cakes included wording and images that the cake shop deemed derogatory. The division also made these determinations because the cake shop would not create cakes expressing the same message for any other customer. The division's determination in these cakes noted that the cake shops would create other cakes expressing different messages for people of faith. The commission later affirmed these determinations.
Any additional comments or?
Yes.
Okay.
Phillips is a cake artist who operates Masterpiece Cake Shop based on his religious beliefs. Phillips is a cake artist. In 1993, Phillips started Masterpiece Cake Shop. Phillips and his wife are the sole owners of Masterpiece Cake Shop. Through Masterpiece Cake Shop, Phillips designed and created custom cakes. These pictures show some custom cakes that Phillips has created. Pictures if anybody wants to see them later. Masterpiece Cake Shop is not just a bakery, it is an art gallery of cakes. Phillips approaches cake designs as an art form. Phillips blends his skills as a pastry chef, sculptor, and painter. After Phillips and his customers agree on the project, Phillips begins the design and creates the cake. Phillips starts by sketching the custom cake design on paper. Phillips then bakes the cake and sculpts it into the desired form. Phillips then decorates the cake using painting and sculpting techniques and inscribing words and numbers and designs. When Phillips creates a custom cake that expresses a message, he is engaging in speech. In addition to being a cake artist, Phillips is a follower of Jesus Christ who bases his religious beliefs on the Bible. Phillips' religious beliefs are central to his life, his identity, and his understanding of goodness, truth, beauty, morality, and existence. Phillips believes that everything he does, including how he operates his business, should be done in the glory of God. Phillips runs Masterpiece Cake Shop based on his religious beliefs. Phillips' operation of Masterpiece Cake Shop is an exercise of his religion. Because of his faith, Phillips hosts Bible studies at Masterpiece Cake Shop. Because of his faith, Phillips welcomes homeless men and women into his store, offers them cookies and brownies free of charge. and befriends them. Because of his faith, Phillips closes Masterpiece Cake Shop on Sundays, which honors God and allows him and his employees to attend religious worship services. Phillips serves all people, but will not create cakes that express messages or celebrate events contrary to his religious beliefs. Phillips serves all people, individuals of all races, faiths, sexual orientations, and gender identities, and will design and create custom cakes for anyone. When Phillips cannot do his creations or make cakes that express messages or celebrate events contrary to his religious beliefs, Phillips' decisions on whether to create a custom cake do not focus on who the customer is, but instead depends on what the customer cake will express or celebrate. Neither Phillips nor any staff member at Masterpiece Cake Shop asks customers about their protected characteristics, such as race, faith, sexual orientation, or gender identity, because those characteristics do not matter to Phillips in deciding whether to accept a custom cake order. Phillips believes that he would violate God's commands if he were to create custom cakes that express messages or celebrate events in conflict with his religion. It is standard industry practice for cake artists to decline to create custom cakes that express messages or celebrate events that they do not want to support or that violate their beliefs. For example, numerous bakeries turned down a request to create a Donald Trump cake for a 9-year-old boy who wanted that cake for his birthday. Phillips has declined to create many custom cakes because of the messages they would have expressed or events that he would not celebrate himself. Because Phillips holds the religious belief that all people are of equal dignity and worth, he has declined and will continue to decline to create custom cakes that demean people. Phillips has declined requests to create custom cakes that demean LGBTQ people. Phillips has declined to create custom cakes that express racist views, including white supremacy ideology. Phillips has declined to create custom cakes that express hateful, vulgar, and profane messages. Because of Phillips' religious beliefs, he will not design or create custom cakes celebrating Halloween. Phillips declines to design or create custom cakes celebrating Halloween, even though Halloween cakes are a significant source of income for many cake artists. Because of Phillips' religious belief, he will not design or create custom cakes promoting the use of illegal drugs or other controlled substances like marijuana and alcohol. Phillips has declined to create custom cakes promoting the use of illegal drugs or other controlled substances like marijuana and alcohol. Because Phillips' faith teaches him that human life is precious and vulnerable from conception to natural death, he will not design or create custom cakes that express support for abortion, euthanasia, and assisted suicide. Because Phillips' faith teaches him that Satan is the cause of great evil and suffering in the world, he will not design or create a custom cake that celebrates or otherwise expresses support for Satan. Phillips has declined to create custom cakes that celebrate or otherwise express support of Satan. Phillips' religious teachings, or actually Phillips' religion teaches him that marriage is a lifelong union between one man and one woman. Phillips will not design or create custom cakes that express or celebrate contrary messages about marriage. Phillips has declined requests to create custom cakes celebrating divorce and cakes celebrating same-sex marriage. Phillips will not create such cakes no matter who requests them. Phillips will create countless other custom cakes for same-sex couples and gay and lesbian individuals. Phillips also believes, as a matter of religious conviction, that sex, the status of being a male or female, is given by God. It is biologically determined, is not determined by perception or feelings, and cannot be chosen or changed. Phillips will not create custom cakes that express messages in conflict with these religious beliefs about sex. Phillips will not create such cakes no matter who requests them. Phillips will create countless other custom cakes for people who identify as transgender. To ensure that Phillips does not design or create custom cakes that express messages or celebrates events in violation of his religious beliefs, he believes every custom cake requested from Masterpiece Cake Shop is an expression of art. When customers request a custom cake, Phillips or his staff ask them about the kind of cake they want, the desired content, colors, themes, words, and styles, and what event, if any, the cake will celebrate. While most of Phillips' work involves the creation of custom cakes, he also sells pre-made items like brownies, cookies, coffee, and generic cakes. Phillips sells those items to anyone who wants them. Phillips has never declined to sell those items to anyone. Phillips associates with and endorses his custom cakes. After Phillips creates a custom cake, he typically places it in a box bearing...
Representative Sanders, can you just hold on one second, please? Members, could you please keep it down in the chamber? We're trying to hear this, whatever report or something that he's reading. Thank you.
Thank you. After Phillips creates a custom cake, he typically places it in a box bearing Masterpiece Cake Shop logo. And I have the logo here if anybody wants to see it. By placing his custom cakes in boxes bearing his logo, Phillips associates with and expresses approval of the cake and any messages it conveys. Phillips gives the box with the cake to the customer who commissioned it. When people see Masterpiece Cake Shop's name and logo on the cake box or otherwise learn that Masterpiece Cake Shop created a custom cake, they believe that Phillips does not object to the created cake, to any message that the cake conveys, or to the event that this cake may be celebrating. Colorado begins its practice of treating Phillips worse than other cake artists because it despises his religious beliefs and how he practices his faith. Colorado refuses to treat Phillips in the same as it treats other cake artists under Colorado statute. In 2013, the division found probable cause to believe that Phillips violated the law when he declined to create a custom cake celebrating same-sex marriage. The commission then filed a formal complaint against Phillips, alleging that he had violated Colorado revised statute by declining to create the cake, and it assigned an administrative law judge to review. After the parties filed a cross motion for summary judgment, the ALJ ruled against Phillips, finding that his decision not to create the cake violated Colorado revised statute. The ALJ explained that under Colorado's public accommodations law, a black baker could refuse to make a cake bearing a white supremacist message for a member of the Aryan nation, and an Islamic baker could refuse to make a cake talking badly about the Quran. The commission affirmed the ALJ's decision. When the ruling in the case, the members of the commission made comments endorsing the view that religious beliefs cannot legitimately be carried into the public sphere or commercial domain, implying that religious beliefs and the persons are less fully welcome to call in Colorado's business community. I think I'll end it right there. Thank you.
Representative Rich.
Thank you, Madam Chair. In support of the L018, I'm going to continue to read the case of Masterpiece Cake Shop versus the Colorado Civil Rights Division, and then Governor John Hickenlooper. Religious hostility and bias surfaced at one meeting when a commission member publicly suggested that Phillips can believe what he wants to believe but cannot act on his own religious beliefs if he decides to do business in the state. Moments later, the commission member went further and stated, if a businessman wants to do business in the state and he's got an issue with the laws impacting his personal belief system, he needs to look at being able to compromise. Masterpiece 138 S Court at 1729. About a month later, the commission met again to discuss Phillips' case, and a different commission member had this to say. I would also like to reiterate that what we said in the hearing or the last meeting, freedom of religion and religion has been used to justify all kinds of discrimination throughout history, whether it be slavery, whether it be the Holocaust, whether it be, we can just list hundreds of situations where freedom of religion has been used to justify discrimination. And to me, it is one of the most despicable pieces of rhetoric that people can use to use their religion to hurt others. The other commission members did not object to those comments, nor did the state disavow those comments in the briefs that it subsequently filed. The commission's specific references to the Holocaust were particularly offensive to Phillips because his father was a soldier in World War II who was part of military efforts that liberated a concentration camp. Despite the commission's members' offensive reference to the Holocaust, Governor Hickenlooper found no reason not to appoint her when her term expired, so he sought to keep her on the commission. Jesse Paul and John Frank, Hickenlooper appointed LGBT advocate, still on the Civil Rights Commission despite Colorado GOP lawmakers' vote to block her. The Denver Post in May 25, 2017, there's an article. And when the Colorado Senate refused to confirm that commission member, Governor Hickenlooper declined to appoint anyone else, thereby allowing that member to remain on the commission under a holdover provision. Once the commission concluded that Phillips had violated the public accommodation law, it ordered him to stop creating wedding cakes altogether unless he agreed to violate his faith by designing custom cakes celebrating same-sex marriage, and to implement a comprehensive staff re-education to teach that Phillips was wrong to operate his business according to his faith, and to provide quarterly compliance reports to the division identifying the custom cake requests that Phillips declines and detailing the reasons why. Because Phillips chose not to violate his religious beliefs, the commission's order forced him to stop creating wedding cakes altogether, which caused him to lose approximately 40% of his income and most of his employees. Phillips appealed the commission's order to the Colorado Court of Appeals. Around that same time, the division and commission issued their determinations in the 3 cases involving William Jack and his request for custom cakes with messages criticizing same-sex marriage. Those determinations exonerated the cake artists who declined to create those cakes. The Colorado Court of Appeals affirmed the commission's order in Phillips' case.
Representative Richfield, 1 moment, members. I understand it's lunchtime. I understand everybody's enjoying some delicious food, but please direct your attention to the well or take your conversations off the floor, please. Thank you.
Thank you, Mr. Chair. The Colorado Courts of Appeals distinguished Colorado's decision to punish Phillips from its decision not to punish the 3 cake shops that declined William Jack's request. Here is what the Court of Appeals said about that. The division found that the bakeries did not refuse request because of his creed, but rather because of the offensive nature of the requested message. Importantly, There was no evidence that the bakeries based their decisions on the patron's religion, and evidence had established that all three regularly created cakes with Christian themes. Conversely, Masterpiece Cake Shop admits that its decision to refuse a requested same-sex wedding cake was because of its opposition to same-sex marriage, which, based on Supreme Court precedents, we conclude is tantamount to discrimination on the basis of sexual orientation. That was Craig versus Masterpiece Cake Shop, Inc., 370 Pacific 3rd, 272, 282, Colorado Court of Appeals, 2015. Phillips then asked the Colorado Supreme Court to weigh in, but it declined. The U.S. Supreme Court granted review on June 26, 2017. Throughout the nearly 6 years that this case was litigated, Phillips endured multiple death threats, repeated harassment, and countless hateful phone calls and emails as a result of Colorado's intolerance toward him. The death threats, harassment, and hateful communications escalated with each new wave of media attention focusing on the case. The death threats, harassment, and hateful communications got so bad that Phillips' wife was afraid to set foot in Masterpiece Cake Shop. Phillips also had rocks thrown through the window of Masterpiece Cake Shop. Because of the threats, harassment, and vandalism, Phillips was forced to install security cameras at Masterpiece Cake Shop to protect himself, his family, his employees, and his customers. The Supreme Court rebukes Colorado for its anti-religious hostility toward Phillips. On June 4, 2018, the Supreme Court released its decision in Masterpiece, which reversed the Colorado Court of Appeals decision and cemented victory for Phillips by declining to remand the case for further provisions. The court rebuked Colorado for violating Phillips' free exercise rights by manifesting hostility toward his religious beliefs and failing to act with the religious neutrality that the First Amendment requires. Colorado showed its anti-religious bias in at least two ways. First, Colorado discriminated against Phillips' religious beliefs by treating his religious objection to creating a custom cake celebrating same-sex marriage worse than the three other cake artists' non-religious objections to create a custom cake criticizing same-sex marriage. The Supreme Court rejected the Colorado Court of Appeals basis for distinguishing Phillips' case from the cases involving the three other cake artists. It said that a principled rationale for the difference in treatment of these two instances cannot be based on the government's own assessment of offensiveness, and that the Colorado court's attempt to account for the difference in treatment elevates one view of what is offensive over another and itself sends a signal of official disapproval of Phillips' religious beliefs. Second, the commission members showed anti-religious hostility when they disparaged Phillips' religion by describing it as despicable, by characterizing it as merely rhetorical, something insubstantial and even insincere, and by comparing Phillips' religious beliefs to defenses of slavery and the Holocaust. Commission members showed further anti-religious hostility when they made comments endorsing the view that religious beliefs cannot legitimately be carried into the public sphere or commercial domain, implying that religious beliefs and persons are less than fully welcome in Colorado's business community. every justice in Masterpiece who opined in the proper interpretation of Colorado's public accommodation law, including the two dissenting justices, indicated that the cake artists do not violate that law by declining to create cakes that express marriage that will communicate for anyone. Justices Kagan and Breyer expressed that view in their concurrence. It is not unlawful for cake artists to decline a request for an expressive cake that they would not have made for the customer, because doing that treats the requester the same way they would have treated anyone else, just as Colorado public accommodation law requires. Cake artists do not engage in unlawful discrimination when they decline to sell a requested cake to anyone. So did Justices Ginsburg and Sotomayor in their dissent. Cake artists do not violate the public accommodation law by refusing to make a cake with requested message for any customer, because an individual who requests the message is treated as any other customer would have been treated, no better, no worse. As did Justices Gorsuch and Alito in their concurrence. Owners do not intend to refuse service because of a customer's protected characteristics if they would not sell a requested cake to anyone. Despite Phillips' victory at the Supreme Court, he still lost his wedding business as a result of the state's unconstitutional actions, and he is unsure whether he will ever restore it to the prior success he achieved before Colorado launched its unconstitutional crusade against him. Neither Phillips nor his family has recovered from the distress of Colorado's unconstitutional actions toward them. The death threats, the state's open hostility toward their faith, and the loss of 40% of their family's income. Next title, Colorado continues its practice of treating Phillips worse than other cake artists because it despises his religious beliefs and how he practices his faith. Colorado responded to the Supreme Court's stinging rebuke of its anti-religious practices by doubling down on its efforts to punish Phillips. A mere 24 days after the Supreme Court released its decision in Masterpiece, the division once again issued a probable cause determination against Phillips for allegedly violating Colorado Revised Statutes 24-34-601-2A. The events that gave rise to that probable cause determination started in June 2017. On June 26, 2017, the same day that the Supreme Court announced that it would hear the Masterpiece case, a Colorado lawyer named Autumn Scardinia called Masterpiece Cake Shop on the phone. The lawyer takes great pride in suing businesses that allegedly discriminate against lesbian, gay, bisexual, and transgender people and serving them their just desserts. Scardina Law, standing up for employees in employment dispute. During this phone call, the lawyer asked Masterpiece Cake Shop to create a custom cake with a blue exterior and a pink interior, a cake design that, according to the lawyer, reflected the fact that the lawyer transitioned from male to female and that the lawyer had come out as transgender. That is the case Cardina v. Masterpiece Cake Shop. The custom cake would have expressed messages. The custom cake would have celebrated an event. Both the message that the cake would have expressed and the event that it would have celebrated conflicted with Phillips' religious beliefs. Phillips has never created a cake like that one before. After the lawyer disclosed the design and message of the desired cake, Masterpiece Cake Shop politely declined the request because Phillips cannot in good conscience express the messages that the cake would have communicated, i.e. that sex can be changed, that sex can be chosen, and that sex is determined by perceptions or feelings, or celebrate the event that the cake would have been commemorated, i.e. the announcement of a change from one sex to the other based on perceptions or feelings. Phillips would not create a custom cake that expresses those messages for any customer, no matter the customer's protected characteristics. Masterpiece Cake Shop did not decline this request because of the customer's transgender status or other protected characteristics. Rather, it declined the request because of the messages that the cake would have expressed. When Masterpiece Cake Shop told the lawyer that it could not create the requested cake, the lawyer asked the shop's representative to repeat that statement so that someone listening over the speakerphone could hear it. Masterpiece Cake Shop offered to create a different custom cake for the lawyer or to sell the lawyer any of the pre-made items available for purchase in the shop. The lawyer did not request that Phillips create a different custom cake, nor did the lawyer attempt to buy any of the pre-made items available for purchase in the shop. When discussing this cake request, Masterpiece Cake Shop communicated with this lawyer only via telephone. Phillips believes that this lawyer on other occasions has requested that he create other custom cakes with messages that violate his faith. One with a cake celebrating Satan, and another was a cake featuring satanic symbols. About a month later, Phillips received a notice from the division informing him that the lawyer filed a discrimination charge against him for the decision not to create the cake with the blue and pink design. The charge alleged that Masterpiece Cake Shop violated Colorado Revised Statutes 2434-601-2A's prohibition against discrimination because of sex and transgender status by declining to create the requested cake. Phillips responded to this charge by denying the allegations of discrimination and by raising statutory and constitutional defenses. On June 28, 2018, a mere 24 days after the Supreme Court released its decision in Masterpiece, the division issued a probable cause determination against Phillips. The division found that the lawyer telephoned Masterpiece Cake Shop and requested a custom cake, not a pre-made one, Scardina versus Masterpiece Cake Shop, Inc. The division found that the lawyer requested a custom cake with a blue exterior and a pink interior and explained that the design was a reflection of the fact that the lawyer transitioned from male to female and that the lawyer had come out as transgender. The division found that only after Masterpiece Cake Shop learned of the requested design and message did it decline to create the cake. The division acknowledged Masterpiece Cake Shop's position that it declined to create the custom cake because Phillips did not want to express through his cake art the idea that a person's sex is anything other than an immutable God-given biological reality. But the division ignored Masterpiece Cake Shop's message-based reason for declining to create the cake. Instead, the division concluded that Masterpiece Cake Shop declined to create the cake based on the lawyer's transgender status. The division determined that Masterpiece Cake Shop violated Colorado Revised Statutes 2436-601-2A and ordered Phillips to participate in mandatory mediation. Director Alanis left no doubt about her position against Phillips when she stated, "I, Director Alanis, determined that Phillips and Masterpiece Cake Shop have violated the public accommodation law." Director Alanis cited the Supreme Court's decision in Masterpiece in her determination, indicating that she had read and interpreted the decision before she issued her determination. Director Alanis acted in bad faith when she made the determination. Director Alanis ignored the Supreme Court's holding that Colorado is motivated by clear and impermissible hostility toward Phillips' sincere religious beliefs. Director Alanis ignored that every justice in Masterpiece who opined on the proper interpretation of Colorado's public accommodation law indicated that cake artists do not violate that law by declining to create cakes that express messages that will not communicate for anyone. Director Alanis ignored Colorado's past practice of allowing other cake artists to decline requests to create custom cakes that express messages they deem objectionable and would not create for anyone. Director Alanis ignored what Colorado represented to the Supreme Court, that cake artists may decline to create cakes with pro-LGBT designs, themes, and messages. Director Alanis' decision to ignore the Supreme Court's holding in Masterpiece, the Supreme Court's view of Colorado's public accommodation law, Colorado's past practice when enforcing its public accommodation law, and Colorado's representations to the Supreme Court is explainable only by bad faith and animus toward Phillips' religious beliefs. Phillips has lost and continues to lose work, time, and profits. He also has incurred and continues incurring expenses as a result of Director Alanis' determination and the rest of the Colorado's unconstitutional conduct toward him. Phillips has suffered and continues to suffer humiliation, emotional distress, inconvenience, and reputational damage as a result of Director Alanis' determination and the rest of Colorado's unconstitutional conduct toward him. Next title. Colorado's current practice is to treat Phillips worse than others because it despises his religious beliefs and how he practices his faith. As a general matter, if a discrimination complaint is filed against a Colorado cake artist for declining to create a custom cake expressing a message he or she opposes, Colorado defers to the cake shop owner's message-based objection and, consistent with what state law requires, does not presume that the owner discriminated against the customer based on his or her protected status, found in Colorado Revised Statutes 2434-3053. But if a discrimination complaint is filed against Phillips for declining to create a custom cake expressing a message that conflicts with his faith, Colorado rejects this message-based objection and presumes that he is discriminated against the customer based on his or her protected status. Colorado does this even though state law requires its enforcement officials to presume that the conduct of any person accused of violating the public accommodation law is not unfair or discriminatory. The unequal treatment confirms Colorado's continuing hostility toward Phillips and his religious beliefs. Colorado has not disavowed its unequal enforcement policy or its hostile comments toward Phillips' faith, even after the Supreme Court condemned them. In fact, the division has released a statement that acknowledges the Masterpiece decision does not disavow either the state's unequal enforcement policy or its hostile comments. And Defendant Kaufman, as the Colorado Attorney General, released a similar statement that acknowledged the Masterpiece decision did not disavow the state's unequal enforcement policy or its hostile comments. In other cases, Colorado continues to manifest the sort of anti-religious hostility that the Supreme Court condemned in Masterpiece. In one case, for example, Colorado similarly labeled a website designer's conservative Christian beliefs offensive and discriminatory. Colorado still harbors hostility toward Phillips and his religious beliefs. Next title. Colorado prohibits Phillips from telling others the messages that he cannot express because of his religious beliefs, and from explaining the religious beliefs that compel him to decline those messages. Phillips seeks to inform people about Colorado's continuing hostility toward his religious beliefs. Phillips and his legal representatives will publish written, electronic, and printed communications that discuss Colorado's recent probable cause determination against him. In those communications, Phillips and his legal representatives will disclose some of the messages that he cannot express his cake art because of his religious beliefs. For example, they will explain while Phillips will gladly create custom cakes for all people, including those who identify as transgender, he will not create custom cakes expressing that sex can be changed, that sex can be chosen, and that sex is determined by perceptions or feelings. In those communications, Phillips and his legal representatives will also discuss the religious beliefs that compel Phillips not to express those messages. But Colorado Revised Statutes 2434-601-2A forbids those sorts of communications. Colorado Revised Statutes 2434-601-2A makes it unlawful for a person directly or indirectly to publish, circulate, issue, display, post, or mail any written, electronic, or printed communication, notice, or advertisement that indicates that the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of a place of public accommodation will be refused, withheld from, or denied an individual because of sexual orientation, which includes transgender status. This law also makes it illegal for a person directly or indirectly to publish, circulate, issue, display, post, or mail any written, electronic, or printed communication, notice, or advertisement that indicates that an individual's patronage or presence at a place of public accommodation is unwelcome, objectionable, unacceptable, or undesirable because of sexual orientation, which includes transgender status. This law nowhere defines unwelcome, unobjectionable, unacceptable, or undesirable. Colorado forbids Phillips and his legal representatives from publishing any written, electronic, or printed communication indicating that Phillips will not create custom cakes, communicating that sex can be changed, that sex can be chosen, or that sex is determined by perceptions or feelings. Colorado also forbids Phillips and his legal representatives from publishing any written, electronic, or printed communication discussing the religious beliefs that compel Phillips not to express those messages. Colorado's enforcement of these provisions under these circumstances restricts Phillips' freedom to publicize his desired messages and to express his religious beliefs. Colorado discriminates based on content and viewpoint because businesses do not violate Colorado law if they publicize their beliefs that sex can be changed, that sex can be chosen, or that sex is determined by perception or feelings, or if they publicize their desire to express those beliefs through the custom items they create. Next title. Colorado rigs the system against people of faith like Phillips. Colorado Revised Statutes 2434-303 1 small b, 1 through 3 prescribes non-neutral criteria for selecting commission members and assigns them non-neutral interests to represent. 2 commission members must represent different parts of the business community. Colorado Revised Statutes 2434-303, paren 1, small b, I, or 1, Roman numeral 1, capital A. 2 other commission members must represent government entities, but when vacancies in those positions occur, those members must be replaced by 1 person who represents a statewide business organization and 1 person who represents an employee association that advocates for Colorado workers. That's found in Colorado Revised Statutes 2434-303, 1 small b, Roman numeral 1, capital B. The 3 remaining commission members must represent the community at large, but when 2 vacancies in those positions occur, those members must be replaced by 2 people who represent employee associations that advocate for Colorado workers. Colorado Revised Statutes 2434-303, 1 small b, Roman numeral 1, capital C. At all times, the commission must include at least 4 commission members who are members of groups of people who have been or might be discriminated against because of disability, race, creed, color, sex, sexual orientation, national orientation, ancestry, marital status, religion, or age. Colorado Revised Statutes 2434-303, 1 small b, Roman numeral 2, capital A. Governor Hickenlooper administers and enforces Colorado Revised Statutes 2434-303 by appointing commission members. Upon information and belief, during the last 6 years, the commission has not had a Christian member who shares Philip's religious beliefs about marriage and sex. Upon information and belief during the last 6 years, the commission has not had any religious member who believes that marriage is the union of 1 man and 1 woman, and that sex is given by God and cannot be chosen or changed. The commission's non-neutral selection criteria, its assignment of non-neutral interests for each commission member to represent, and the absence of members who share Philip's religious beliefs played a role in creating and has served to entrench the commission's hostility toward Philip's religious beliefs. The commission's non-neutral selection criteria and its assignment of non-neutral interest for each commission member to represent embed bias into the very structure that Colorado uses to enforce its public accommodation law. That bias has manifested itself in Colorado's unconstitutional treatment of Phillips.
Representative Bradfield.
Thank you. Thank you, Madam Chair. The way in which Colorado enforces its public accommodation law against Phillips empowers anyone to harass or prosecute him by simply requesting a cake with a message that conflicts with his faith on a topic that implicates one of the classifications protected under that law. Based on Colorado's past conduct, Philip reasonably fears that discrimination charges will continue to be filed against him and that he will continue to face punishment from biased state officials. In the past year alone, Phillips has declined several requests to create custom cakes because of the messages that they would have communicated or the events that they would have celebrated. Phillips believes that many of these requests are not genuine. Rather, they are setups designed to get him to decline the desired message. Phillips believes that the originator of a number of these requests is the attorney Autumn Scardina. In late September 2017, someone emailed Phillips asking for a custom cake to celebrate Satan's birthday. The customer requested that the cake have red and black icing and include an upside-down cross under the head of Lucifer. The customer described the cake as religious in theme and reminded Phillips that religion is a protected class. Phillips declined to create that cake because it included designs that would have expressed messages in violation of his religious beliefs. A few days later, someone called Phillips asking for a similar custom cake. Phillips noted that Scardina appeared on the caller identification screen. Phillips believes that the caller was Autumn Scardina. The caller asked Phillips to create a birthday cake for Satan. The caller requested that the cake feature a black and red theme and an image of Satan smoking marijuana. Phillips declined to create that cake because it included designs that would have expressed messages in violation of his religious beliefs. On June 4th, 2018, the day that the Supreme Court issued its masterpiece decision, someone emailed Phillips claiming to be a member of the Church of Satan. The person asks for the following cake. I'm thinking of a 3-tiered white cake, cheesecake frosting, and the topper should be a large figure of Satan licking a 9-inch dildo. I would like the dildo to be an actual working model that can be turned on before we unveil the cake. I can provide it for you if you don't have the means to procure one yourself. Phillips declined to create that cake because it included designs that would have expressed messages in violation of his religious beliefs. A few weeks later, 2 people visited Master Cake Cake Shop and asked for a custom cake with a pentagram, a symbol commonly linked to witchcraft. When Phillips asked for the customer's name, one responded, Autumn Marie. Phillips believes that customer was Autumn Scardina. Phillips declined to create that cake because it included designs that would have expressed messages in violation of his religious beliefs. Whether sincere inquiries or setups, Phillips will keep receiving and declining requests for custom cakes expressing messages in conflict with his faith. Colorado's actions in crediting and pursuing these claims is encouraging and enabling people to continue to file these claims against Phillips. So long as Colorado remains hostile to Phillips because it despises his religious beliefs and practices, Phillips' future as a cake artist is in jeopardy. Phillips cannot remain a cake artist if Colorado continues to declare that he is in violation of the public accommodation law. Whenever someone wanting to harass him for his religious beliefs files a discrimination charge after requesting a custom cake that expresses a message in conflict with Phillips' belief about a subject that relates to a protected classification. Legal allegations. Phillips and Masterpiece Cake Shop are subject to and must comply with Colorado law, including the public accommodation law. Defendants acted under color of Colorado statute, ordinance, regulation, custom, or policy when committing all of the acts alleged in this complaint. Defendants' treatments of Phillips and Masterpiece Cake Shop under Colorado public accommodation law violates their constitutional rights. Defendants' treatment of Phillips and Masterpiece Cake Shop under Colorado's public accommodation law prevents them from exercising their constitutional rights. Phillips and Masterpiece Cake Shop suffer ongoing irreparable harm as well as economic and non-economic injury, including emotional distress and other comprehensible damages from defendants' conduct. Unless defendants' conduct is enjoined, Phillips and Masterpiece Cake Shop will continue suffering irreparable harm as well as economic and non-economic injury, including emotional distress and other comprehensible damages. Defendant Elena's acted and is continuing to act intentionally, either with malice or reckless indifference to Phillips and Masterpiece Cake Shop's constitutional rights. Defendant Elena's acted and is continuing to act in bad faith and with hostility and animus toward Phillips and Masterpiece Cake Shop. Phillips and Masterpiece Cake Shop seek punitive damages against defendant Elena's in order to deter her and others similarly situated from engaging in similar conduct in the future. First cause of action, free exercise of religion. Plaintiffs restate each allegation contained in paragraphs 1 through 279 of this complaint. The First Amendment of the United States Constitution protects Phillips and the Masterpiece Cake Shop's rights to freely exercise their religion. The First Amendment protects Phillips and Masterpiece Cake Shop from government hostility, targeting, and discrimination because of their religious beliefs and practices. Defendants' interpretation and enforcement of Colorado Revenue Status, paragraph 24 through 34-601 2 small a, targets, shows hostility toward, and discriminates against Phillips and Masterpiece Cake Shop because of their religious beliefs and practices. The First Amendment requires defendants to act in a neutral and generally applicable manner toward Phillips and Masterpiece Cake Shop and their religious beliefs and practices. The Free Exercise Clause bars even subtle departures from neutrality on matters of religion, and its protection applies even upon slight suspicion that states' actions stem from animosity to religion or distrust of its practices. Masterpiece 138 South Court, maybe, at 1731, quote, Church of the, I'll give it my best, Lukumai Babalu I Incorporated versus the City of Hialeah, 508 U.S. 520, 534, 547, paragraph 1993, paragraph emphasis added. Defendant's interpretation and enforcement of Colorado revised statutes, paragraph 24, 34, 601, 2, small a, is neither neutral nor generally applicable toward Phillips and Masterpiece Cake Shop and their religious beliefs and practices. Defendants' actions are not just subtle departures from neutrality, they are blatantly and brazenly hostile toward religion. The First Amendment also protects Phillips and Masterpiece Cake Shop's rights to operate consistently with their religious beliefs, to decline to operate in violation of their religious beliefs, to express messages that are consistent with their religious beliefs, and to decline to express messages that conflict with their religious beliefs. Defendants' interpretation and enforcement of Colorado Review Statutes, paragraph 24-34-601, 2, small a, prevents Phillips and Masterpiece Cake Shop from operating consistently with their religious beliefs, from declining to operate in violation of their religious beliefs, from speaking their religiously motivated messages, from declining to speak messages that would violate their religious beliefs, and from adhering to key aspects of their faith. Defendants' interpretation and enforcement of Colorado Revised Statutes, paragraph 24-34-601, 2A, violates the hybrid rights doctrine. Defendants' interpretation and enforcement of Colorado Review Statute, paragraph 24-34-601, 2, small a, imposes severe cohesive pressure on Phillips and Master Cake Shop to change or violate their religious beliefs or exercise. Defendants do not further any compelling or even legitimate interest in a narrowly tailored way by infringing on Phillips and Masterpiece Cake Shop's free exercise rights. Phillips and Masterpiece Cake Shop suffer ongoing harm because of defendants' interpretation and enforcement of Colorado Revised Statutes, paragraph 24-34-601, 2A. Accordingly, as applied to Phillips and Masterpiece Cake Shop, defendants' interpretation and enforcement of Colorado Revised Statute 24-34-601, 2, small a, violates Phillips and Masterpiece Cake Shop First Amendment right to freely exercise their religion. Second cause of action, free speech. Plaintiffs restate each allegation contained in paragraphs 1 through 279 of this complaint. The First Amendment to the United States Constitution protects Phillips and Masterpiece Cake Shop's right to speak, to decline to speak, to create speech, to decline to create speech, to distribute speech, to sell speech, to operate in an expressive business, to associate with others for the purpose of engaging in expression, to decline to associate with others for the purpose of engaging in expression, to be free from content and viewpoint discrimination, to be free from unconstitutional conditions, to be free from vague laws giving unbridled discretion to government officials, and to be free from overbroad laws regulating speech. Phillips and Masterpiece Cake Shop engage in protected expression. Representative, your turn.
Representative Sandridge.
Thank you, Mr. Chair. So I started reading this at the very beginning and discuss how it correlates with this amendment and how important it is to understand the specifics of this complaint and how this amendment could actually could have helped some of this situation. But in conclusion, I'm going to finish it up here. In conclusion, it's almost finished. Phillips and Masterpiece Cake Shop are constitutionally protected speakers who creates custom cakes that express messages. In the first clause of the Colorado Revised Statute, it states, it's unlawful for a person directly or indirectly to refuse, withhold from, or deny to an individual or group because of a protected classification like transgender status, the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of a place of public accommodation. Defendants' interpretation and enforcement of Colorado Revised Statute, first clause infringes Phillips and Masterpiece Cake Shop's First Amendment free speech rights. It does so by forcing Phillips and Masterpiece Cake Shop to speak and create custom expressive cakes that communicate messages in violation of their religious beliefs. It also does so by pressuring Phillips and Masterpiece Cake Shop to stop speaking and creating custom expressive cakes altogether in order to avoid violating their religious beliefs. Defendants' interpretation and enforcement of this Colorado Revised Statute, first clause, also infringes Phillips and Masterpiece Cake Shop's First Amendment freedom of expressive association. It does so by forcing Phillips and Masterpiece Cake Shop to collaborate and associate with others in order to create and disseminate expression that violates their religious beliefs. Forcing Phillips and Masterpiece Cake Shop to create and disseminate expression that violates their religious beliefs significantly impairs their ability to express their desired messages. Phillips and Masterpiece Cake Shop suffer ongoing harm because of defendants' expression and enforcement of this Colorado Revised Statute. The second clause of this statute makes it unlawful for a person directly or indirectly to publish, circulate, issue, display, post, or mail any written, electronic, or printed communication, notice, or advertisement that indicates that the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of a place of public accommodation will be refused, withheld from, or denied an individual because of a protected classification like transgender status. Defendants' interpretation and enforcement of this Colorado Revised Statute, the second clause infringes Phillips and Masterpiece Cake Shop's First Amendment free speech rights. It does so because defendants interpret this statute's second clause to prohibit Phillips and Masterpiece Cake Shop from speaking about their religious beliefs and the message that they cannot express as a result of those religious beliefs. In particular, the defendants interpret that the provision to prohibit Phillips and Masterpiece Cake Shop from announcing that they will not create custom cakes communicating that sex can be changed, that sex can be chosen, that sex is determined by perception or feelings. Nor may Phillips or Masterpiece Cake Shop explain their religious reasons for declining to speak those messages. The third clause of the statute makes it unlawful for a person, directly and indirectly, to publish, circulate, issue, display, post, or mail any written, electronic, or printed communication, notice, or advertisement that indicates that an individual's patronage or presence at a place of public accommodation is unwelcome, objectionable, unacceptable, or undesirable because of a protected characteristics like transgender status. Defendants' interpretation and enforcement of the statute, third clause, infringes Phillips and Masterpiece Cake Shop's First Amendment free speech rights. It does so because Colorado interprets the statute as a third clause to prohibit Phillips and Masterpiece Cake Shop from speaking about their religious beliefs and the messages that they cannot express as a result of those religious beliefs. In particular, defendants interpret that provision to prohibit Phillips and Masterpiece Cake Shop from announcing that they will not create custom cakes communicating that sex can be changed, that sex can be chosen, that sex is determined by perception or feelings, nor may Phillips or Masterpiece Cake Shop explain their religious reasons for declining to speak those messages. This statute's third clause is also unconstitutionally vague, factually, as it applies, because it is impossible for Phillips, Masterpiece Cake Shop, or anyone else to know the kinds of communications that, in defendant's view, indicate that an individual's patronage or presence is unwelcome, objectionable, unacceptable, or undesirable because of their transgender status. This statute, revised statute's third clause, is also factually overbroad because it outlaws Phillips and Masterpiece Cake Shop's communication about the message that they will not express due to their religious beliefs. Phillips and Masterpiece Cake Shop currently suffer ongoing harm because of defendant's interpretation of this revised statute. Defendants do not further any compelling or even legitimate interest in a narrowing, tailored way by infringing Phillips and Masterpiece Cake Shop's free speech rights. Accordingly, as applied to Phillips and Masterpiece Cake Shop, defendants' interpretation enforcement of this statute, first, second, and third clauses violates their First Amendment free speech rights, and both factually and as applied to Phillips. Masterpiece Cake Shop, Colorado Revised Statute, blah, blah, blah. Third clause violates the First Amendment right to free speech, free from vague and overbroad speech regulations. Fourth clause of action, equal protection. Plaintiffs restate each allegation contained in paragraph 1 through 279 of this complaint. The 14th Amendment to the U.S. Constitution agrees equal protection of the laws. Defendants' interpretation and enforcement treats Phillips and Masterpiece Cake Shop's decision to create speech and their religious exercise differently from those similarly situated to them. Defendants' discriminatory interpretation of enforcement by this statute infringes on Phillips and Masterpiece Cake Shop's fundamental rights, including their free exercise, free speech, and due process rights. Accordingly, as applied to Phillips and Masterpiece Cake Shop, defendants' interpretation and enforcement of this statute violates Phillips and Masterpiece Cake Shop's equal protection rights. Prayers for relief. Yes, that's what it says. Prayers for relief. Plaintiffs ask for this court to enter judgment against defendants and provide the following relief: a preliminary and permanent injunction forbidding defendants and any person acting in concert with them from
Representative Sanders, I have a question about how a previous pleading in an already decided case is germane to this amendment.
Because how we discuss it is if this amendment, or how this amendment would help the violation that's so established in what I'm reading right now.
Thank you, Representative.
And I'm almost finished.
A prayer for relief. And if you're almost finished, I'll give you a little more leeway. A prayer for relief is a specific request in a legal document in a different proceeding than this one right here. So if you could please move on as quickly as possible.
Would you like me to skip that portion?
There's a lot of things I'd ask you to skip.
I mean, if you want,
but yeah, I want to make sure that we're actually speaking to the amendment.
I'll do a solid and I'll skip. Well, you know what? Actually, there's 2 pages left. I'm going to read. How about I read the final pages?
Excellent.
Okay, thank you. A preliminary and permanent injunction forbidding defendants and any person acting in concert with them from enforcing Colorado Revised Statute, third clause, which makes it unlawful for a person directly or indirectly to publish, circulate, issue, display, post, or mail any written, electronic, and printed communication notice or advisement that indicates that an individual's patronage or presence at a place of public communication is unwelcome, objectionable, unacceptable, or undesirable because of a protected status like transgender status. A declaration that Colorado Revised Statute, blah, 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 violates Phillips and Masterpiece Cake Shop's rights under the Due Process Clause of the 14th Amendment by prescribing non-neutral selection criteria and non-neutral interests for each commission member to represent. And the final page, in conclusion. An award of compensation damages against defendant including but not limited to damages for lost work, lost profits, expenses caused by unconstitutional actions. An award punitive to the amount of $100,000, an award of $1 of nominal damages to each plaintiff against each defendant, any other relief that the court deems equitable and just under circumstances. The end. I hope we all learned a little something, a little clarification. So, and I hope we learned how this amendment is needed through through this complaint. So, thank you for your understanding, Chair.
Is there any further discussion on L018? Seeing none. The question before us is the adoption of Amendment L018. All those in favor say aye. Aye. Those opposed, no. No. L018 is lost. To the bill, Representative Pico.
Thank you, Mr. Chair. I will be brief. I would like to read a letter from the Colorado Catholic Conference in opposition to the bill. This letter was written for the committee, but it is applicable to the bill as a whole, and I'll paraphrase portions of it. And if you'll pardon me, my eyes aren't quite what they used to be. From the Colorado Catholic Conference, which is the united voice of the 4 Catholic bishops of Colorado in public policy. This is on behalf of this conference in opposition to House Bill 1108. The Catholic Church teaches that each person should be treated with dignity, respect, and compassion as each person is made in the image of God. And I want to stress that. Each person be treated with dignity, respect, and compassion. House Bill 1108 claims to ban discrimination based on sexual orientation, gender identity, and gender expression. However, it actually codifies discrimination against anyone with a different belief about human sexuality and forces them to conform to government-mandated beliefs about sexual orientation, gender identity, and gender expression under threat of criminal and financial penalties. While House Bill 1108 contains some religious institution exemption clauses, it is unclear that these clauses will truly allow religious organizations to both profess and practice their well-founded convictions on human sexuality and marriage without being prosecuted for violating the law. For instance, religious exception to the public accommodation anti-discrimination requirement is narrow, although it does not apply to, quote, a church, synagogue, mosque, or other place that is principally used for religious purposes, unquote. The exemption does not apply to religious affiliated institutions like schools or hospitals that likely are not principally used for religious purposes. This means that Catholic schools, Catholic hospitals, homeless shelters, adoptive care agencies, and other ministries of the church may be forced to conform to these government-mandated beliefs on sexual orientation, gender identity, and gender expression, or be prosecuted. Additionally, the bill affords no protections for private individuals to practice their well-founded convictions on human sexuality in the public sphere. This brings back the 2017 U.S. Supreme Court case, Masterpiece Cake Shop versus Colorado Civil Rights Commission, in which Masterpiece owner Jack Phillips was sued for politely refusing to design a wedding cake for a same-sex marriage due to his religious beliefs on marriage. The Colorado Civil Rights Commission found Jack violated anti-discrimination law. However, in a 7-2 ruling, the U.S. Supreme Court found that Colorado was wrong to punish Jack for peacefully living out his beliefs in the marketplace. This bill is against U.S. Supreme Court precedent. If enacted, House Bill 1108 gives authority to that same Colorado Civil Rights Commission to enforce this new law and decide how religious expression and worship are applied for religious institutions and private citizens, which means it actually codifies discrimination against anyone with a different belief about human sexuality. We respectfully ask for a no vote on House Bill 1108. And I want to stress that although this is from the Catholic Conference of Colorado, it is applicable to any religion or no religion. Thank you.
Representative Carver.
Thank you, Mr. Chair. I rise in opposition to the bill. And we have tried to put in the record the fullness of our constitutional concerns, whether it is freedom of religion, freedom of expression, to include prohibitions against compelled or coerced speech, viewpoint discrimination, as discussed by the Supreme Court, particularly when viewpoint discrimination results in targeting of those with a disfavored view. My final closing remarks want to touch upon another serious issue with this bill. At the beginning of our debate on this bill, Representative Soper had some discussion about how the definitions went from a somewhat objective standard to a very subjective standard. And for example, the definition of sexual orientation changes from an objective listing of different types of sexual identity to the individual's identity in relation to gender or genders to which the individual is sexually or emotionally attracted, and the behavior or social affiliation that may result from that attraction. Some of the phone calls I've received, not from businesses opposed to the goal of the bill, but asking the question, if the bill passes, how do I need to adjust my personnel policies? My charitable organizations like homeless shelters or others, looking at this new definition, which imposes a legal obligation that is subjective based upon how the individual identifies, which can be a range of identities or expressions. And the question was, and coming from, quite frankly, the part of the business or organization that deals with legal compliance, is, so how would we need to adjust our policies based on this language? And I said, well, I don't know, because the language, at least to me, appears to be subjective. So I think that certainly has been part of the discussion when we moved away from definitions that were either established at a federal level or in earlier Colorado laws, that creates a challenge for those that want to comply in good faith and simply look at this language and don't know what adjustments they need to make. So the final point I'll make, which is something that I look at in all the bills, is the final point about constitutionality, which applies to all legislation. The Due Process Clause says, under the 14th Amendment, that the law, particularly laws that have sanctions associated with their violation, the law must give notice to its citizens on what is prohibited and what is allowed. These new definitions do not do that. They do not give notice to what is prohibited and what is allowed, and what the different organizations, businesses, charitable organizations, what adjustments they will need to make in their policies and practices. And I think that is an issue that we should always consider when we're writing legislation. And so with that, Mr. Chair, I ask for a no vote.
For any further discussion? Representative Soper.
Bonjour. Merci, Mr. Chair. I also continue to rise in opposition of this bill, and do want to echo what Representative Carver was just saying. I'm a little bit taller. We've certainly laid out the case for why we object to the language that's here in this particular bill. We don't necessarily, object to the bill as a whole. I want to lay that clear, but we certainly object to the definition that's here. The opening amendment that I ran would have changed the definition of gender expression and gender identity back to what's in law, to add consistency of law as what's already laid out in 18.1.901.3H.5. And to be consistent, we certainly believe in the consistency of law and the ability for Coloradans to know what accepted definitions are. If this bill passes in its current form, we will actually be introducing two competing definitions of the same meaning into Colorado law: gender expression and gender identity. To also echo what my good colleague from Colorado Springs was talking about, the Supreme Court has a very long and well thought out case law record of void for vagueness under the 14th Amendment of the United States Constitution. The issue is whether words and phrases are so vague and so indefinite that any penalty prescribed by their violation constitutes the denial of due process of law. In reading 3.3 in the bill on page 3, if you're following, it talks about gender expression means an individual's way of reflecting and expressing the individual gender to the outside world, typically demonstrated through appearance, dress, and behavior. Earlier in the debate, we talked about why typically is a problem, that we don't have any other definition in Colorado law where typically is included in the definitions section. You do find that other places, but that usually is referring back, not in a definition. Into the vagueness side of things, in looking at the definition, an individual's way of reflecting and expressing the individual's gender, this is an entirely subjective definition that we have here, and it's very difficult from day to day or even hour to hour how an individual is going to change on how they reflect. Having a little bit more of an objective standard would help not only the individual, but it would help the person who's interacting with that individual to decide on, on how they're going to interact. This is incredibly vague. And going back to the case law, when it's so vague that a person of common intelligence has to guess at the meaning, it leaves the average person, the average Coloradan, to the peril of summons and complaint for an unwise exercise of decision-making. Members, just in reading this, to tell the average Coloradan that when they're interacting, and we're talking about constitutional rights here, that they have to now guess at what the individuals are reflecting and expressing themselves is going to mean. This is very difficult to be able to not only understand, but to wrap your head around. And then the fact that in the end of the definition, it talks about appearance, dress, and behavior, but yet in committee, we brought out on the record that looking at other states and other jurisdictions, for example, the European Union, or even case law, speech and mannerisms is almost always talked about in terms of gender expression, but yet that's left out of this definition. So does that mean that the authors of this definition decided that speech and mannerism would no longer be gender expression in Colorado law and are specifically cutting that out? Well, as we found out from testimony in committee, a couple of attorneys who were there to testify said that, well, that could be put back in to be more consistent with case law. And then they told us that everything after the word typically was to hit upon an element that was found in case law. But yet specifically they left out two elements that are quite commonly found in case law when talking about gender expression, which adds to the whole vagueness argument that if a person sitting on the committee can sit back and review different cases and be able to find where there's a void element, a lacking element, an unclear element in this definition, how is the average Coloradan expected to be able to determine what this particular definition actually means? How is an employer supposed to understand what this definition actually means? I think we owe it to the law to have clear and precise definitions, ones that won't be found unconstitutional for vagueness. Mr. Chair, I once again rise in opposition and would ask for a no vote. Thank you.
Representative Titone.
Thank you, Mr. Chair. No person in this chamber knows what it's like to be transgender or non-binary. Not any single one of you know what it's like. Some may be empathetic, and some may have an understanding, like the sponsor of the bill. She knows a lot about this, but she doesn't know what it's like to be me. Nobody does. Not one single person. This bill puts into law what we already do. We already do this kind of stuff here. I stand before you today asking for respect. I've seen some respect in this chamber before. I've been treated with respect from the majority of people. From time to time, I want that to continue. I want that respect. That's what I want. We're talking about people like me with this bill. We're not talking about these people that don't exist. We're talking about me. I'm your colleague. You're talking about me, the person who was standing right up there just a few minutes ago. And you're down here just saying all this stuff. This is so fitting that this bill is happening on Trans Day of Visibility. I don't know if you timed it, but thank you. That worked out really well. It's time that our laws officially recognize trans and non-binary people. It's time that we respect our trans and non-binary citizens in this state by acknowledging that we exist by passing this law. Please vote yes on this bill. Thank you.
Further discussion on House Bill 1108. Seeing none, the question before us is the adoption of House Bill 1108. All those in favor, please say aye. Aye. Those opposed, no. No. House Bill 1108 is adopted. Madam Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
Seeing no objection, the committee will rise and report.
The House will come to order. Mr. Gregorio, please read the report of the Committee of the Whole.
Mr. Speaker, your Committee of the Whole begs leave to report it as under consideration the following attached bills, being second reading thereof, and makes the following recommendations thereon. House Bill 21-1108 as amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. Senate Bill 12 passed on second reading and ordered revised and placed on the calendar for third reading and final passage.
Representative Tatone. You have heard the motion. There are amendments at the desk. We are going to start with the Carver amendments. Representative Mr. Gregorio, please read the first Carver amendment to the report of the Committee of the Whole.
Representative Carver moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Carver Amendment L005 to House Bill 21-1108 to show that said amendment passed and that House Bill 21-1108 is amended passed.
Representative Carver. Members, we please direct your attention to the bill. Representative Carver.
Thank you, Mr. Speaker. I move the Carver Amendment to the Committee of the Whole and ask for an aye vote.
The amendment has been properly moved and displayed. Majority Leader Eskar.
Thank you, Mr. Speaker. I respectfully ask for a no vote.
Is there any further discussion on the first Carver amendment to the report of the Committee of the Whole? Seeing none, Mr. Gregorio, please open the machine and members, please proceed to vote. Those participating remotely, Representative Judah, how do you vote?
No.
Representative Judah votes no. Representative Jackson, how do you vote?
No.
Representative Jackson votes no. Representative McLaughlin, how do you vote?
No.
Representative McLaughlin votes no. Representative Hooton and Representative Ricks. Representative Hooton will be marked excused. Please close the machine. With 23 aye votes, 39 no votes, and 3 excused, the first Carver amendment to the report of the Committee of the Whole is lost. Mr. Gregorio, please read the second Carver amendment to the report of the Committee of the Whole.
Representative Carver moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Carver Amendment L006 to House Bill 21-1108 to show that said amendment passed and that House Bill 21-1108 is amended passed.
Representative Carver.
Thank you, Mr. Speaker. I move the Carver Amendment to the Committee of the Whole and ask for an aye vote.
Majority Leader Eskar.
Thank you, Mr. Speaker. I would ask for a no vote.
Is there any further discussion on the second Carver amendment to the report of the Committee of the Whole? Seeing none, Mr. Gregorio, or the question before us is the adoption of the second Carver amendment to the report of the Committee of the Whole. Mr. Gregorio, please open the machine and members, please proceed to vote. And Representative Hooton is here. That is a $5 fine, Representative Hooton. Representative Judah. How do you vote? Representative Judah votes no. Representative Jackson, how do you vote?
No.
Representative Jackson votes no. Representative McLaughlin, how do you vote?
No.
Representative McLaughlin votes no. Representative Arndt. Please close the machine. With 23 aye votes, 40 no votes, and 2 excused, the second Cutter Amendment to the report of the Committee of the Whole is lost. We will move on to the Soper amendments. Mr. Gregorio, please read the first Soper amendment to the report of the Committee of the Whole.
Representative Soper moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Soper Amendment L004 to House Bill 21-1108 to show that said amendment passed and that House Bill 21-1108 is amended passed.
Representative Soper.
Thank you, Mr. Speaker. I move the first Soper Amendment to the Committee of the Whole and ask that it be displayed.
That has been properly moved and displayed. Representative Soper.
Thank you. I'd ask for a yes vote.
Madam Majority Leader Eskar.
Thank you, Mr. Speaker. Wow. I ask for a no vote on this amendment. Thank you.
Is there any further discussion on the first Soper amendment to the report of the Committee of the Whole? Seeing none, the question before us is the adoption of the first Soper amendment to the report of the Committee of the Whole. Mr. Gregorio, please open the machine and members, please proceed to vote. Representative Judah, how do you vote?
No.
Representative Judah votes no. Representative Jackson, how do you vote?
No.
Representative Jackson votes no. Representative McLaughlin, how do you vote?
No.
Representative McLaughlin votes no. Representative, our majority leader team, please close the machine. With 23 aye votes, 40 no votes, and 2 excused, the first Soper amendment to the report of the committee of the whole is lost. Mr. Gregorio, please read the second Soper amendment to the report of the committee of the whole.
Representative Soper moved to amend the report of the committee of the whole to reverse the action taken by the committee not adopting the following Soper amendment L002 to House Bill 21-1108 to show that said amendment passed and that House Bill 21-1108 is amended passed.
Representative Soper.
Thank you, Mr. Speaker. I move the second Soper amendment to the committee of the whole report and ask that it be displayed.
It has been properly moved and displayed. Representative Soper.
Thank you, Mr. Speaker. So this amendment, we talked about it quite a bit. This is the one that takes the definition of gender identity and gender expression back to what's currently in Colorado law. It's really important that we have consistency in definitions from one part of statute to the other part of the statute, because these terms do not change as you're going from one element to another element, and that I believe we owe a duty to the law, to the people of Colorado, to pass consistent laws, and I would ask for a yes vote. Thank you.
Majority Leader Escar.
Thank you, Mr. Speaker. Not to repeat what I said on seconds, but the combined definitions of both terms slightly differ than from what is used before to now. This bill actually is a way of implementing common language instead of relying on enumerated lists that quickly become outdated as years go by. I ask for a no vote.
Is there any further discussion on the second Soper amendment to the report of the committee of the whole? Seeing none, the question before us is the adoption of the second amendment to the report of the committee report of the committee of the whole from Representative Soper. Mr. Gregorio, please open the machine and members, please proceed to vote. Representative Judah, how do you vote?
No.
Representative Judah votes no. Representative Jackson, how do you vote?
No.
Representative Jackson votes no. Representative McLaughlin, how do you vote?
No.
Representative McLaughlin votes no. Please close the machine. With 23 aye votes, 40 no votes, and 2 excused, House Bill 11, the second Soper amendment to the report of the committee of the whole is lost. Mr. Gregorio, please read the third Soper amendment to the report of the committee of the whole.
Representative Soper moved to amend the report of the committee of the whole to reverse the action taken by the committee in not adopting the following Soper amendment L007 to House Bill 21-1108 to show that said amendment passed and that House Bill 21-1108 is amended passed.
Representative Soper.
Thank you, Mr. Speaker. I move the third Soper amendment to the committee of the whole and ask that it be displayed.
Has been properly moved and displayed. Representative Soper.
Thank you, Mr. Speaker. So as we talked about during the debate, the word typically, which is found in the definition, and then there's the very brief list of how to interpret, is listed after. That's not found in statute in a definition. As a matter of fact, you could say, typically, what does that actually mean? And then on top of it, through appearance, dress, and behavior, there's actually a lot that's missing off this list. So if we really wanted to list everything that's in case law, this actually would be a list that's probably 5-10 times as long as it is here. And that either we're going to be consistent and list everything that has been interpreted in case law, or we should leave it just at the definition itself without injecting this highly subjective element into a definition that I believe is attempting to be quite objective. So this takes it back to, I believe, what would really be a decent definition. And I would ask for a yes vote. Thank you.
Majority Leader Escar.
Thank you, Mr. Speaker. I'd ask for a no vote.
Is there any further discussion on the third Soper amendment to the report of the committee of the whole? Seeing none, the question before us is the adoption of the third Soper amendment to the report of the committee of the whole. Mr. Gregorio, please open the machine and members proceed to vote. Representative Judah, how do you vote?
No.
Representative Judah votes no. Representative Jackson, how do you vote?
No.
Representative Jackson votes no. Representative McLaughlin, how do you vote?
No.
Representative McLaughlin votes no. Please close the machine. With 23 aye votes, 40 no votes, and 2 excused, the third Soper amendment to the report of the committee of the whole is lost. That brings us, there are no further amendments at the desk. The question before us then is the adoption of the report of the committee of the whole. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative Judah, how do you vote?
Yes.
Representative Judah votes yes. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Tipper. Please close the machine. With 40 aye votes, 23 no votes, and 2 excused, the report of the committee of the whole is adopted. Majority Leader Escar.
Thank you, Mr. Speaker. I move the balance of the special orders calendar be moved back to general orders calendar and be laid over to tomorrow, April 1st.
Seeing no objection, the balance of the special orders calendar will be moved to the general orders calendar, which will be laid over until Thursday, April 1st. Majority Leader Escar.
Thank you, Mr. Speaker. I think the chairs will probably make their own announcements, but I just want to give everyone kind of a general idea of what's happening next. Hopefully, the upon adjournment committees that are scheduled to meet will still meet if they can around 1:30, meaning that our afternoon committees that normally start at 1:30 will probably start at 2:15, but I will let each committee chair determine that, and I just want to personally thank the chairs for their patience today as we moved through this bill. Thank you.
Further announcements and introductions. Representative Weissman.
Thank you, Mr. Speaker. Judiciary members, as the Majority Leader just stated, we're going to be starting our afternoon work a little bit later because on adjournment committees need some time. Plan on not sooner than 2:15. It could be a bit later. I'll be getting updates. Watch your text. I've communicated with the ranking member. Same bills, 1101, 1142, same room, 107, on or after 2:15. See you there.
Representative Young.
The Education Committee will meet at 1:30. Be there quickly so we can get done, so Representative Weissman can have his room for judiciary.
Representative Roberts.
Thank you, Mr. Speaker. The House Business Affairs and Labor Committee will also meet at 1:30, so in about 10 minutes to hear 1216, Senate Bill 141, and Senate Bill 96 in 112.
Representative Lontine.
Thank you, Mr. Speaker, and hopefully the Business Committee will be finished so that we can begin the business of the Health and Insurance Committee at 2:15. I will try to keep an eye on that and will text everybody and let you know if that changes, but please be prepared to be in room 112 for the Health and Insurance Committee to hear House Bill 1202. Thank you.
Representative Exum.
Thank you, Mr. Speaker. The same House Transportation and Local Government, instead of meeting at 1:30, we will meet at 2:15. If that changes, I will let you know. Thank you.
Representative Van Winkle.
Thank you, Mr. Speaker. I've asked for permission to be excused on Thursday, April 8th, and received approval from the Minority Leader and actually the Assistant Majority Leaders. Thank you.
Approved. See no further announcements or introductions. Majority Leader Escar.
Thank you, Mr. Speaker. I move that the House stand in recess until later today.
The House will stand in recess until later. Well, actually, sorry, we have some work real quick, so sorry about that.
Is everyone away though?
Well, maybe we'll just save the work. See no objection. Sorry, Mr. Gregorio. See no objection. The House will stand in recess until later today.